Yes. Why? Mr. J.I. Borbunia, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous. Taking into account the above, the writ petition therefore stands closed. Interim orders, if any, stand vacated.
We do consider item number 26. Mr. Phone number file, phone number 8, file. Only time you can number.
Interim,
No interim.
at the request of the petitioner, the matter stands adjourned to be listed again on a conjunction calendar. Ito ko ni Paligyo. Hital Gusaribo, we listed on 7th of October. Yes, what do you want? We'll see what effective orders can be passed. Okay. You wait there. We'll see when the matter reaches.
No,
Item number 5, same order like A2. Item number 2. VK Borua, huh? Infructuous. Item number? Wow. Why? Stay. It has been submitted by the learned counsel appearing on behalf of the petitioner that there is no interim orders operating. The counsel appearing on behalf of the petitioner seeks for certain accommodation. Accordingly, the matter stands adjourned to be listed on 4th of November 2026. At the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed on 16th of November. Huh?
Infructuous.
Why?
But the resolution of the no country was the resolution of 2016.
None appears on behalf of the petitioner on call. Mr. P. Hazarika appears for a response number
9 to 16. 9 to 16.
9 to 16. And Mr. H. Sharma appears on behalf of Learned Additional Senior Government, appears for respondent so-and-so. P. AI appears on behalf of for response number 3 and 4. The present writ petition has been filed by the petitioner assailing the resolution dated 23/5/2016. Where is that?
Yes.
Which pertains to a no confidence against the president of Borbogia Gao Panchayat.
And it's page 99.
Period of the panchayat is long over, and as such, nothing remains in the instant writ petition. Under such circumstances, it is therefore seen that the petitioner is not represented. Accordingly, the writ petition therefore stands closed, as it has become infructuous.
Okay.
Okay. None appears on behalf of the petitioner on call. It is also seen that on various occasions the petitioner has been asked to take steps. The petitioners have not taken any steps. Records also show that the petitioner had also not appeared on the last occasion. You are there? Oh, yes. What is your matter? Let us see. You have not taken steps. Why? You have to give a copy of the writ petition. The counsel appearing on behalf of the petitioner submits that within 7 days from today. Madam, I think when your senior is coming, we'll dismiss the writ petition. You cannot file a writ petition in this manner. Whoever it is, he doesn't know ABCD of pleadings. Let us see what is that notice. Inform you that you have honor occupying a plot of land on National Highway so and so. Oh. What is your instruction?
Lordship, as because the copy is not served upon us, Lordship, I think.
Not you also.
Lordship, yes,
He has
Lordship.
not been given to
No,
you
Lordship,
also.
no, yes, Lordship.
Sir, only 7 days time, senior has been instructed me to inform you about his honorable court. As the file
It
is
is a matter
misplaced.
of 2018, and if you have not given any copy, it is seen. Now, from a perusal of the writ proceedings, it is seen that the petitioner have assailed a notice dated 24/2018, issued by the respondent number 4. Respondent number 5. Directing the petitioner to remove the shop, / house, / tempo stand, / mini truck stand within a period of 3 days from the date of issuance of the said notice. By an order dated 3/5/2018, the learned coordinate bench of this court, while issuing notice making it returnable on 30/5/2018, have passed an interim or direction that the petitioner shall not be evicted from the plot of land covered by Dag number 492 of NK Patta number 28 of Revenue Village Muguria under Uttar Bozali Moza till the next date. The records further reveal that since then, till date, the interim order have not been extended. The learned counsel who appears on behalf of the respondents submit that though notice was issued on 3/5/2018, no steps have been taken. And as such, the respondents are not in a position to obtain the necessary instructions. The learned counsel appearing on behalf of the petitioner submits that the file has been misplaced and as such no steps have been taken and request for 7 days. Considering the above, list this matter on 28/8/2026. In the meantime, the petitioner is directed to effect service upon all the respondents. Mr. H. Sharma, who appears on behalf of the Circle Officer Bozali Revenue Circle, shall also obtain instructions as to whether the petitioner in the meantime have been evicted, taking into account that the interim order have not been extended beyond 30/5/2018. If your senior was there, I would have dumped this writ petition there. It is because of you I have not dumped it till now. My goodness, 8 years, no steps. Yes, what is this?
My lord, there is a, my lord, order 5/8/26 of the Lazima Court, wherein the petitioner, he appeared and, my lord, submitted that the matter has been rendered infructuous, my lord. There is an order of Lazima 5/8/26.
And appears on behalf of the petitioner on call. Mr. S.K. Talukdar appears on behalf of the Corporation Department. The case of the petitioner herein is that the elections to the Olgapur SS Limited should not be conducted without correction of the voters list.
Of 2019.
In the year 2019. It is also seen that on 4/10/2019, this court had only issued notice. The materials on record therefore show that the instant writ petition has become infructuous during the pendency of the instant writ petition. It therefore appears that the petitioner have lost interest in the present proceedings for which the petitioner is not represented. Accordingly, the writ petition stands closed as infructuous.
Right.
There is an IA for appointment of a commission because when the respondent number 4 says there is an alternative route for approaching his house. The petitioner, my lord, if your lordship takes up this IA 1948, or your lordship may hear the whole matter was against an order of eviction
Eviction from where?
from the, my lord, approach road. Approach road is there. If your lordship looks into, your lordship has taken writ petition.
Yes.
Then page 26, your lordship will kindly see. There is he purchased the land in the year 1995 and he has been using
Page
this
26 is a part of something, a sale deed.
part of sale is it. Page 28, my lord. 27 is the, my lord, trace map. 28. This approach road, the whole building has been there. And that just entry, my lord. That entry is a government land and he has been using since the purchase of his land in the year 1995, my lord. And prior to that, the owner of the land from where he purchased. So almost 50 years. So we filed an application for settlement of the land.
Which
At
land?
This 10 lachas of land, approach road. My lord.
Which portion you are referring to?
My lord, the first portion,
Residence of Ugra Goswami.
this is the Ugra Goswamis I purchased from Ugra Goswami. And this, my lord, front, my lord, this, my lord, your lordship will kindly see this.
Down
This
below.
is the- Yes.
D
Front portion, yes.
is marked with D.
D, my lord, yeah.
And which is your house?
This rest are my house, my lord. Only the D is approach road. I am using it for ingress and egress, my lord. But, and I have filed for application for settlement also that they have not looked into. At the instance of the respondent number 4, private respondent, they
So
have
you
issued a
submitted
notice
this
for eviction,
application in 2009.
2009.
Now what has happened in that?
Nothing, no information has been given. And they have given a notice, my lord, your lordship will kindly look into that notice at page 37. Earlier also they have given notice in the year 2011. They have not done anything. Now this page 37, they have given a notice that within 3 days, you remove. There is a gate. If I do not put the gate, my lord, it will be anybody can come into my house. And if your lordship looks into this page 120, number.
Now what do you want in the IA?
I am, because the private respondent says that you have a separate road for entering into a house. Separate road.
Why the
He-
private respondent has come into the scene?
At her instance, my lord, all these notices have been issued.
Yes.
And I have given reply to the notice.
We have not filed our affidavit, lordship, but instructions is here. May I please? Itu দিব না?
Yes, sir.
This 732 and this Dag number, according to the circle officer, is a government Dag.
Yes, it is a government land. I am not denying it. But that is the road, only road.
Encroachment is there, lordship. It is used as
It-
a road
Who is
and
Mosumi Borwa? You are.
yes,
Yes.
wife of George Choco or
Yeah, Mosumi Borwa has been pressing a plot of land.
Okay, bhai. That where is the road here?
they
That
were
map there.
directed to remove the encroachments over the road.
There is only a gate entering my house. And this, if this is stop, I will have no approach road for entering my house.
So who is George Cheko?
George Sacco is the owner of the land who purchased the land in the year
The husband of the
1995.
husband of the petitioner.
এটা কোন হলো?
Husband of the petitioner.
Yes,
But this notice has
Photograph
been
have
issued
given?
to George Cheko.
yes.
Wait. 124. Your lordship may kindly look into page 124 also, my lord.
So where is your land? Your land is in, you have purchased which land?
In
Dark
the year
number?
1995,
You
dark
purchased
number-
the land when?
1995, 25/8/95 at page 22, my lord.
From, this is one katha, 10 acres of land in
Along with building.
dark number 99. Where is 99?
99 is after crossing that,
99.
yes, sir,
Okay, so that is the land.
land.
Now you are occupying 732.
Not occupying, I am using it as a
You
ingress.
are
Yes,
occupying,
yes,
obviously. You
yes.
don't have a right to
Yes.
reside there. And the other one is 668. 688. Which is 688? That is the road.
Road, my lord.
And you have filed a settlement application where, for which land?
Same 10 lachas of land.
Hmm?
Page 29. Dark number 732. Even user right will also do, my lord, because I
This
have
is, you are asking for 732.
732.
You are not asking for 688.
No,
So you want the front portion of your land,
yes,
which is there.
yes.
6.
Otherwise also the user right will also do, my lord, because
Huh?
user right will also do, because there is, that is the only approach road to.
So no, but 688,
Yes,
you are in occupation. But you have a right of way from 688.
there is no right of way, my lord, in, that is a boundary wall, my lord. My lord,
688 is a government land. It's used as a road.
my lord,
Kindly
in that,
come to page 27. 688 is a government land. It's used as a road.
page 27, my lord.
Uh,
732 is the approach road.
no, 732 is another plot of land, which
Yes.
is 1 kata 10 lectures, where you have filed an application for
For
settlement.
settlement, yes.
You have not asked for settlement for 688.
688, no, that is a road.
That's the road.
That road touches the plot of the land of the petitioner.
It touches
Understood.
only. yes,
That
sir.
is another aspect of the matter. Now, who is the private respondent? What is the private respondent's claim? Yes,
Private
Mr. Chaudhary, what is your claim?
Sir, I am, my lord, one of the, my lord, general public, my lord, who resides, my lord, in that locality. And that
Far
road,
away
my lord,
from-
that, my lord, dark number 732 has been reserved by the government for the purpose of widening the road, which is covered by dark number 688, my lord. He is, my lord, saying that he has no other access, but if your lordship kindly allows me to pass over this map, my lord, your lordship will see lands covered by dark number 80 and, my lord, 673 touches on his land. It is a public road, my lord.
What 670? 688 and 673.
My lord, 673, 688 actually does not touch. It touches this land, 732. That is why, my lord, this 732 has been reserved for the purpose of widening the road, my lord. This road is very narrow, my lord. People cannot use it for the ingress and egress with their mobiles, motor cars or whatever. They cannot, the government thought it proper to widen that road, my lord. Hence,
Understood.
Huh.
There may be, but the question is 732 is the land.
Is the land.
But why in the notice
My
it
lord.
is mentioned that the petitioner is in occupation of 632, 688? Where is the notice?
Because, my lord, 688 is adjacent to 732, my lord.
Maybe.
There he has constructed a
That
wall
I
and then
understand, but I'm not on that. My question is why the notice says, where is the notice? Yes. 688. Is the petitioner in occupation of 688? No.
no. 732
That's a
only.
road, my lord.
So then why the notice says about 688?
Because he has constructed a wall, my lord, on the road land that is adjacent to 732, which is 688, my lord.
Has he constructed anything in 688?
He has constructed a house, my lord. No, not on 688, on 732.
Therefore, why the notice says about this?
It says, my lord,
And what type of
688
notice
and
is this when there
732 of
is a-
Sohar Gauhati Part 7 under Ulubari Moza has been found to be encroached. You are therefore directed to vacate the said plot of land as per Rule 18.3 of the Assam Land and Revenue Regulation within a period of 3 days from the date of receipt of the notice.
This notice has to go. It cannot remain.
There is one another aspect, my lord, because he cannot be allotted to the land, because if your lordship is aware, my lord, Rule 23 of the Assam Land and Revenue Regulations, it says that, my lord, since for a particular area, my lord, there cannot be any allotment from the middle portion of the road, my lord.
Well, for a second, my lord, may I take your lordship to page 124?
And I have, my lord, filed a
what
detailed
you
objection
see-
as regards this, my lord,
No, no,
my
no.
lord,
688
my lord,
is the road.
is the road, my lord.
732 is not a road.
Not a road. 732 is a government land which is now being used by the government, proposed to be used by the government for the purpose of widening 688.
Understood. But have you rejected his application for settlement?
My lord, that in 2009, my lord, from whatever, in my affidavit in opposition, my lord, I had given several
You are
letters, my lord,
nobody. You are nobody to say all
my
this.
lord.
We'll hear you. I only asked you, who are you?
My lord.
Nothing more than that. Yes.
That is the instruction, lordship, that much.
Have you rejected the petitioner's application? Petitioner has nothing to do with 688.
Lordship,
His only thing is 732. Now, 732, you have to consider his application.
lordship,
Now, that application has been filed then. If you
Lordship.
want, the petitioner will again file another application. But his notice cannot be sustained in law. Mr. Das, you now file an application fresh for settlement, giving reference to the earlier application. One, only for 732 for settlement, they will consider. In the meantime, we set aside this notice and dispose.
it's because lordship now,
My lord,
it's a 2021 notice, lordship. At that time, these mistakes were there.
My lord, I just wanted to, your lordship is taking, it's all right, my lord, I agree. Page 124, for a moment. Your lordship will kindly see what they are trying to do.
এনেকা না আমার ইয়াতে সিরিয়াল প্রেজেন্টেশনটো নাই কোনখনত আছে নকলে আৰু কি চাম
That road your lordship has seen, and down my lord left hand side, that is 732, it enters my house. So how will I go to my house, my lord, without this approach road? And that gate I have put it.
Therefore, I'm setting
Yes, that's all
aside.
right. Yes,
What-
ma'am.
What is your main prayer? For
That's all
setting
right.
aside that.
That's all
notice?
right, my lord.
I'm setting aside the
lord.
notice. You submit a fresh application giving reference to the earlier applications, and they will consider. I
lord.
cannot consider for settlement. Now, they will consider as to how it is to be there.
Yes.
Now, whether at that point of time you knew about this to be the government land, you took it, and then that is at your own risk.
Yes, ma'am. 50 years, my lord, even under easement act, my lord, I get the right for user, my lord, right of use.
Not against the
lordship
government.
most probably the circle officer will get that liberty to file to issue a fresh notice by following due process of law, lordship, if necessary.
You can do so.
My lord, settle.
But
Lordship.
see, there is a reason why. If you want to do it very well, you do it. But you need take note of his application.
Yes, that settlement, lordship. Yes, lordship, yes.
Because as on now, I cannot direct on the basis of this application.
My lord.
Page 29, I cannot direct because
Yes, sir.
now that it has to be done in the Seva Situ portal. You apply. I make it on observation in my judgment that you have applied in the year 2009
My lord.
and have been asking for, requesting that in the meantime, the land policy has changed. So now you have to apply as per that. You will make a fresh application.
My lord, only thing is, my lord, if they do not settle, I may be allowed to use the land, user right. Under the easement act, your lordship knows, section 15, that,
Mr.
that also
Das,
they may consider.
Mr. Das, the thing is, you have to understand the jurisdiction of the court also.
My lord.
Would
I
it
leave
be
it.
proper on my part to ask them to allow you to use that
No,
in
no,
the
that's
case
all
of a civil
If they
suit?
do not settle it, my lord. That's all right, but I'll do.
Best case is once I set aside this, you file a civil suit and say not to interfere from them, get an injunction
My-
and let it continue
that-
for years.
Oblige.
Heard Mr. B.D. Das, the learned senior counsel, assisted by Soen on behalf of the petitioner. Mr. H. Sharma appears for the respondent number 2 and 3 and 5. You are appearing, you are Rima Goswami.
I'm for the renegation.
Mr. So-and-so appears on behalf of the respondent number 4. The present writ petition has been filed by the petitioner. Assailing the notice dated 1/9/2021 issued by the respondent number 3, and further seeking directions upon the respondent authorities for consideration of the petition application submitted by the petitioner for settlement of 1 katha 10 lechas of land covered by government DAG number 732. From the materials on record, it is seen that the petitioner by the deed of sale, the petitioner, your husband is not there. Husband is there. Is he a party?
No, he's not a party.
And the notice was issued to the husband. Why the wife has filed?
Wife, because the husband stays well, in different places. Well, he was, at that point of time, his husband's father was ill at a relevant point of time. So he had to go to Kerala.
It is the case of the petitioner that by the deed of sale bearing deed number 4062/95 dated which was registered on 25/8/2025, 1995. The petitioner, along with her husband, purchased a plot of land measuring 1 katha 10 lechas, covered by DAG number 99 of KP Pata number 449 within Sahar, Gauhati, Part 7, under Ulubari Moza in the district of Kamrup. For the purpose of ingress to the said plot of land which was purchased, there is a government DAG. There is a government land which is covered by DAG number 732, which the petitioners have been using it for their ingress and egress. Petitioner, along with her husband, has been using it for their ingress and egress. This government DAG was also used by the vendors of the petitioner, since 1981. After the purchase of the land in DAG number 99, in the year 2009, the petitioner's husband submitted an application for settlement of the 1 katha 10 lechas of land which is covered by DAG number 732. The said application still remains unconsidered, though the petitioner and her husband have been, the petitioner's husband had submitted reminders. Be that as it may, on 1/9/2021, a notice was issued by the respondent number 3, directing the petitioner's husband to vacate the plot of land covered by DAG number 688 and 732 of Sohar Gauhati Part 7 under Ulubari Moza under Rule 18.3 of the settlement rules framed under the Assam Land and Revenue Regulation 1886 within a period of 3 days. The petitioner submitted a representation. Petitioner submitted representations to the Circle Officer, Gauhati Revenue Circle, as well as also to the Deputy Commissioner and the Chairman Land Advisory Committee on 3/9/2021. Having not received any favorable response, the petitioner has approached this court by filing the present writ petition. The records reveal that the learned coordinate bench of this court, by an order dated 6/9/2021, issued notice and thereupon and also passed interim directions that the petitioner should not be evicted from DAG number 732 at Sohar Gauhati Part 7 under Ulubari Moza District, Kamrup Metro, in terms with the notice dated 1/9/2021 issued by the Circle Officer. The interim order thereupon had been extended from time to time. This court further takes note of that the respondent number 2 had filed an affidavit in opposition, wherein it is mentioned that the land in question measuring 10.38 lechas, bracket 1.39 R, covered by DAG number 732, KP Patta number 462. These people, they don't know. DAG number 732 is a government land. Which it measures 10.3896 R. Is it R or what?
1.39 hour, my lord.
Huh?
Otherwise, lectures is 10.38.
Paragraph
Respondent
Kindly
vote two.
come to Annexure C of the affidavit of the government. Ten point 3896 lectures.
Yes, my lord.
I think
Lectures.
that is the proper. It measures 10.3896 lectures. And the said land have been included for road purpose to be utilized by the person adjacent, person. I'll say, it's a government land. 10.38 R is a government covered by DAG number 732 is a government land which has been encroached by the petitioner by constructing a boundary wall and iron gate. It was also mentioned that the land in question have been included for road purpose by an order dated 28/8/1989 issued by the additional deputy commissioner and the subsequent direction dated 6/9/1989 issued by the sub-deputy collector. The respondent number 4 has also filed an affidavit in opposition. Wherein it is mentioned that the petitioner has suppressed that there was a proceedings initiated for their eviction from the government lands way back in 2011 by eviction case number 22/2011 initiated by the then additional deputy commissioner Kamrup Metro, which implied that the alleged application dated 6/2/2009 for settlement of the government land in Greater Gauhati had been rejected. It was further mentioned that the petitioner and her husband had narrowed down the public road by encroaching upon the land of DAG number 732. And on account of the construction of the guardwall, the municipal corporation is not in a position to construct the public road. An affidavit in reply was filed, affidavit in reply had been filed by the petitioner on 19th of December 2025. That wherein it is mentioned that the land in dispute at measuring 10.38 lechas, bracket 1.39 R, covered by dark number 732 is a government land, but the petitioners has been using the small portion of land for their ingress and egress to their house situated at dark number 99. It was also mentioned that though application was submitted for settlement, but the authorities have not responded. And the petitioner as well as their predecessor for the last 55 years have been using the said land. Photographs of the land have been enclosed to the affidavit in opposition, affidavit in reply. Another affidavit in reply has been filed by the petitioner against the affidavit in opposition filed by the respondent number 4. In the backdrop of the above, this court heard the learned counsels appearing on behalf of the petitioners parties. Mr. B.D. Das, the learned senior counsel, submitted that the dark number 732, which is a government dark, which at measure 10.39 R, is the only road by which the petitioner and her husband can ingress and egress to their plot of land. The learned senior counsel also submitted that a due application was filed in the year 2009. Until date, the said application have not been rejected. In addition to that, the learned senior counsel also submitted that a perusal of the notice which is impugned in the instant proceedings would show that the said notice is contrary to the provisions of Rule 18.3 of the settlement rules, and that too without giving an opportunity to show cause that the petitioners have a bona fide claim of right involved in the said land. Per contra, Mr. G. Chaudhary, the learned counsel appearing on behalf of the respondent number 4, submits that on account of the petitioners' encroachment upon the number 732, the public road, which is a narrow strip, which is the existing public road, which is narrow, cannot be widened. In addition to that, referring to the affidavit filed by the respondent number 2, the learned counsel further submitted that the said tag have been reserved for road, and under such circumstances, the notice which was issued was in a sense a notice under Rule 18.2 of the settlement rules. I've also heard Mr. H. Sharma, the learned additional senior government advocate, who also submitted that the land under the occupation of the petitioner is dark number 732. He also further submitted that the notice though mentions 688, but the petitioner is not in occupation of dark number 688. This court have given an anxious consideration to the respective submissions and have perused the application so submitted by the petitioner's husband on 5/2/2009, seeking settlement of of the land covered by dark number 732. This court have also taken note of the notice of the trace map, which has been enclosed to the writ petition as Annexure 2 Collie. And from a perusal of the said trace map, it is apparent that the land cover included in dark number 732 abuts the land belonging to the petitioner, which is at dark number 99. Further to that, a perusal of the notice, this court have also perused the notice issued by the respondent number 3, wherein the petitioner was asked to vacate within a period of 3 days in exercise of the powers conferred under Rule 18(3) of the settlement rules. H. Sharma, the learned counsel also submitted that in view of the Assam land policy of 2019, if the petitioner application as it stands cannot be considered and it has to be filed in the Seva Setu portal. The notice dated, let this court first take note of the notice dated 1/9/2021. A perusal of the said notice would show that the said notice is contrary to Rule 18(3) of the settlement rules. Apart from that, the said notice is in violation to the principles of natural justice, inasmuch as the petitioner was not given an opportunity to show cause. Under such circumstances, the notice dated 1/9/2021 cannot be sustained in law. This court also cannot turn a blind eye to the fact that merely being in occupation of a government land, there is no right to be allotted the said land. At best, it may be a case wherein the petitioner can be considered or her husband can be considered for allotment. This aspect would be apparent from the Assam Land Policy 2019, and more particularly clause 14.3, which is reproduced here in under. This court also takes note of the trace map, whereby the ingress to the egress and ingress to the petitioner's land is through Dag number 732.
My lord, if I-
And under such circumstances, if the land cannot be settled, the authorities can very well provide a way to the petitioner, provide a passage to the petitioner to ingress to the ingress and egress to the petitioner's land. It is going to be a road.
My lord. No,
So-
my lord, what I say is, my lord, if the lordship kindly see this map, this is the complete map, my lord. The map shows, my lord, that there is a road, public road already in existence, which touches upon.
Understood, it will be a road. Mr. Chaudhary, whatever me. 730, your case is 732 is road. It has been reserved as a road. So therefore, when it is a road, can't there be slight diversion so that the petitioner can be accommodated?
It's already there. That is what I wanted to say. It is already there.
So that can be very well accommodated by the authorities. The petitioner may not have a right over the land, but he can very well use it.
No, no, that public road by which he can go to his place is already there in the map. It is a public road. It is already there. Without my lord enforcing upon the 732, he can also access his lands. That is what I wanted to tell you. By that road, which is covered by Dag number, my lord, 80 and 670.
This court have also perused the trace map and closed at Annexure 2 Collie. And it is the case of the petitioner that the only ingress and egress to the petitioner's land is through Dag number 732. On the other hand, the respondent, number 4, disputes the same. This court also takes note of the affidavit filed by the respondent number 2, wherein it is mentioned that even prior to the petitioner purchasing the land, there has been orders passed by the additional deputy commissioner as well as the sub-deputy collector in the year 1989 that the Dag number 732 has been reserved for road. Under such circumstances, it is the opinion of this court that the respondent authorities, before initiating it is the opinion of this court that at the time of consideration of the petitioner's application for settlement, the respondents shall also take note of as to whether the petitioner have any other access to the land of the petitioner. Accordingly, the incident with petition therefore stands disposed of with the following observations and directions. The impugned notice dated 1/9/2021 is set aside and quashed. Number 2, taking into account the Assam land policy of 2019, and the requirement of submitting an application for allotment only through the Sewa Setu's portal, the petitioner is granted the liberty to submit such application for seeking settlement of the land covered by DAG number 732, provided the said land is in the records maintained as wasteland. Full stop. The said application be filed within a period of 30 days. Full stop. Number 3. The respondent authorities, more particularly the respondent numbers 1, 2, and 3, shall duly consider the petitioner's application. Keeping in mind that settlement can only be granted, keeping in mind clause 14 of the Assam Land Policy 2019. And further, if the land is a wasteland, land contained in DAG number 732 is a wasteland. Now, it is further observed that in the circumstance, the petitioner cannot be granted a settlement of the land as the authorities concerned, or the authorities concerned shall duly now, this code further directs that the authorities, while taking up the issue of settlement, shall also consider as to whether the petitioner have any other access to the land of the petitioner. This court further observed that observations, this court further, before parting with the record, this court observes that the setting aside of the notice dated 1/9/2021 shall not preclude the respondent authorities to take steps against the petitioner in respect to the land pertaining to the DAG number 732 by following the due process.
Diploma.
I close. Take on point. No?
May I,
This,
may I please your lordship, this
Uh.
matter may pass over for the time being.
why?
My senior is appearing in another court.
What is the matter, madam?
My lord, this is the Myanmar citizenship, my lord. The petitioner is and deportation case, my lord. After conviction, my lord, of 4 months.
Then what does he want?
One is for the after 4 months and one is 2 years. Item number,
Now, what does he want?
my lord, they want to go back.
Who?
That is, my lord, kindly come to item number.
So they have been held to be foreigners.
Yes, my lord.
Now they want to go back.
Yes, my lord.
Why you are not sending it?
My lord, they are due to some process. Kindly give some time, my lord. Just now I have communicated to the MHA, my lord. Give me some time, my lord. I'll take the proper instruction on that, my lord.
Okay. The petitioners herein, the petitioners in the petitioner herein who have been held as a foreigner under the Foreigners Act of 1946.
Yes, my lord.
Is aggrieved by the inaction on the part of the respondent authorities in not deporting the petitioner to their homeland after completion of the sentence of 2 years. The writ petition has been filed in the year 2022 and 4 years have passed by. Ms. Aga and the learned CGC seeks for some more time to obtain instructions from the Ministry of Home Affairs.
Yes, my lord.
Taking into account the above, list the matter on 2nd of February 2026.
Must apply.
Rita De.
Wait, please. The office note dated, my lord, 16/6 reveals that 4, 5 and 9, the respondents have been served through speed post.
I have been served a copy of a rejoinder.
Service complete.
Rejoinder copy has been served today, my lord.
Insofar the
I filed a rejoinder. A copy has been
Service
served.
complete.
service is complete. As per this, my lord, order dated 16/6, my lord.
Service being complete, list the matter for admission. Urgency, no urgency.
As your lordship pleases, subject to your lordship's
On
convenience.
16th of November 2026. In the meantime, the other respondents who have not filed their response shall file their response.
Like,
Yes,
May I please, Lordship?
infructuous.
The Lordship, no Lordship, Lordship, respond
Why
number,
haven't you taken steps then?
today, Lordship, I take steps, Lordship, in respond number 5, Lordship. Private respondents,
What is the matter about?
the land acquisition, Lordship. I am the patta holder, Lordship. Petitioner, the petitioner is the patta holder, Lordship.
So what?
The Lordship.
You're not taking steps.
Today, Lordship, today I steps, Lordship.
The writ petition, in the instant writ petition, notice was issued on 19/12/2022.
Respond number 5, Lordship.
But till date, the service upon the respondent number 5 is not complete. In spite, full stop. It is also seen that the petitioner have What is your matter about?
The Lordship, the land acquisition, Lordship, in the Lordship, the state highway.
Huh?
State highway is construction, Lordship.
What?
In the Barbados district, Lordship.
If you have any problem with your land acquisition, you have not been paid, somebody else has been paid,
Lordship.
isn't it? Then why you're not going under section 69? It is done acquisition under what provision?
The
LA case number?
there is no Lordship. The petitioner submitted the representation before the deputy commissioner. Lordship.
No.
The Lordship, the page representation, Lordship, 35, Lordship. Page.
Any instructions? Huh? Why? Why no instructions?
I'll get it within 2 weeks, man.
Next week. This is a simple matter. It doesn't take time. Yeah, we don't require all these people. So Mr. Endas shall obtain instructions from the
Circle officer. DC and circle officer.
respondent numbers 2 and 4. 2 and 4, na?
Yes, my lord.
Respond number 2, 3, and 4.
3, 4.
As to the status of the land acquisition proceedings and the petitioner's representation so submitted to the respondent number 2 in connection with LA case number
My lord, there's only page 32 says that it has been acquired for the state highway. From Langa to Barpeta. No LA case, my lord. Under what?
What is the name of the petitioner?
The Hormuz Ali and Muhammad Ali, Ahmad Ali, and the Ghazi.
Exonia Patta.
Sonia.
Action Battal.
And you have not received the compensation.
No, no, no.
Why LA case number is what? Do you find it? This document, nobody can read it. LA case number what?
LA case 9/9
9 of
2011 12.
2011.
11 12.
11-12. In connection with LA case number 9/2011-12, which was initiated for improvement and strengthening of NSH2, including double laning of the existing carriageway under ASRP for
Carrying away under SSS.
huh?
For existing carriage carrying
away under ASRP for
Langla to
we dismiss
Portion.
your petition
Portion
for
Nangla to Barbada. The
we do one thing, we dismiss your petition. The first, how can you submit such document and you are certifying it?
Lordship, this is the Lordship, the clear document is not available, Lordship.
So
With the
you know the LA number.
the Lordship.
the thing is in the pleadings.
LA case number 9 of the
From
2011.
Langa.
Langa
There is one word.
Nangla, Lordship. Nangla to
From
Barbada.
Langla. Langla to Borpeta
Good better.
town. Langla
LA
to
case
Borpeta
number
town.
9 of the
Oh,
2000.
stop. List this matter on 16th of November 2026. Did you have it early? Just find it out. Just find out what it happened.
16th of September, my lord.
Huh?
16th of September.
Okay, 21st of 14th September.
Number to the
Copy. নাই পেন। এটা copy পন।
What is it?
My lord, direction to my lord, pay the contractual dues was given, my lord. On the last occasion, lordship has suggested, because we have disputes, my lord, we are in the process of filing a review, my lord. Another week may be given, my lord. We will file it.
I have not suggested.
What?
It is your lookout.
We will file a review. We will file a review, my lord. Just some more time we are seeking.
Mr. I. Botakud, the learned counsel, if after the respondent submits that by the order dated 19/6/2023, asked in WPC number 7995/2022, there was a direction to pay an amount of rupees 3,54,344 for the materials supplied to the department pursuant to the work orders mentioned in the said order. The learned counsel submitted that when verification was conducted, it was found that the bills and challans which were submitted on the basis of which the petitioner had claimed the amount, there is the said documents would not, on the basis of such documents, the petitioner cannot claim the entitlement. To the amount of rupees 3,54,344. During the course of the hearing, this court inquired with the learned counsel appearing on behalf of the respondent that on account of the doctrine of non-traverse, this court was compelled to pass the order dated 19/6/2023 in WPC number 7995/2022. And as such, the said order, unless being reviewed or appealed and interfered with, the respondents are bound to make the payment. The learned counsel appearing on behalf of the respondent submits 2 weeks' time may be granted in this regard. List this matter after when?
My lord,
18 September.
18th September.
You have not filed the amended cost
My
title?
lord, we have put it on bio of an affidavit, my lord, but it is not on record, my lord.
What?
This amended cost title, my lord.
Amended cost title is not required to be
My,
filed by
my,
affidavit.
my lord, oh no, my lord, direct amended has been filed, my lord, not bio of an affidavit, my lord.
It has been submitted by Mr. A.R. Bhuya, the learned senior counsel.
Affidavit, no, no.
The amended cost title has been filed on
My lord, yesterday, no? Yesterday, my lord.
yesterday. What is the matter about?
My lord, this is that the eviction matter, my lord, from the forest land, my lord. This is in fact, my lord, is the first writ petition, my lord, when we, in the year 2025, this was filed. My lord, there are admittedly subsequent developments are there, my lord, but I have taken the instruction that, my lord, till date, the petitioners are there, their houses are there.
Which forest?
And my lord, it is South Number Reserve Forest, my lord.
Notice has been issued.
Notice,
Orders have
yes,
been
yes.
given.
Yes, my lord, notice has been issued, it starts at page 78, my lord.
But these are earlier notices.
Earlier notices, but after
have
the,
have you initiated in terms with the other one,
no, my lord.
As per the
Abdul Khalik?
Abdul Khalim, my lord, I will have to take instruction because so far we have not been.
Take your instruction by
Well.
2 o'clock. If you have not, then we close
My lord.
close this repetition, allowing it saying that now you will follow as per Abdul Khalik and do the needful.
Yes,
My lord.
I'll take
That
instruction.
is the only way out. Unnecessary keeping this matter pending would not help you out. No?
Interim, sir, interim, no?
Obviously, you have not done. This is a case of 2025. The Abdul Khalid judgment came
Later on.
when? Obviously, you have not done the cause of action.
Then Lordship may dispose of saying.
Abdul Khalid. Heard Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner. Petitioner, learned senior counsel appearing on behalf of the petitioners. Learned senior counsel assisted by so-and-so appearing on behalf of the petitioners. Mr. I. Botakur appears on behalf of the Forest Department.
Forest.
The present writ petition has been filed by 15 writ petitioners who have been issued notices on 24/7/2025, collectively enclosed as Annexure 1 to the writ petition. Wherein the petitioner were alleged to have entered into the South Nambor Reserve Forest situated under Nauzan Range Forest Office. It is relevant to take note of that pursuant thereto, that is, Abdul Khalek is also involved South Nambor.
My lord,
number.
my lord.
Pursuant thereto, the Supreme Court in the case of Abdul Khalek versus State of Assam and others reported in so-and-so.
Abdul Khalek or SLP Kuswa.
Reported in 2026.
February dispose করেছে যে। SLP কেমন?
CC Online SC 184
2-3.
have disposed of a batch of special leave petitions thereby directing the Forest Department to carry out a fresh process for removal of the encroachment conforming to the principles of fairness, reasonableness, and due process. Article 12 and 13 of the said judgment being relevant is reproduced hereunder. Article 12, 13, and 15 of the said judgment being relevant. 14 and 15 of the said judgment being relevant are reproduced hereunder. It is relevant to take note of that in the case of Abdul Khalek, Supra, amongst the 4 forests, reserve forests, which were the subject matter, One of such reserve forest was South Nambor.
my lord.
Subsequent thereto, subsequent to the directions passed by the Supreme Court in the case of Abdul Khalik, in terms with the directions, steps were taken by the Forest Department of the government of Assam in coordination with the revenue officials in respect to the four forests, and various speaking orders were passed. These speaking orders were put to challenge by various writ petitioners in by various persons who were directed to be evicted, who were asked to put to challenge by various writ petitioners, various persons in another round of litigation before this court, which includes, amongst others, the writ petition filed by one Negbor Ali alias Negbor Ali and 88 others versus State of Assam, reported in 2026 GAU-AS:8021. The said judgment dated 8/6/2026 was assailed before the division bench of this court in various writ appeals so filed. The said writ appeals were dismissed by the learned division bench of this court. It is also relevant to take note of that while the said writ appeals were dismissed, while the writ appeals were pending, a special leave petition was filed by one Abdul Noor and others before the Supreme Court against the judgment dated so and so, passed in 8/6/2020, passed in WPC number 1690/2026. And the said special leave petition was also dismissed by the Supreme Court by an order dated 27/2026. In the backdrop of the above, taking into account the directions which were passed by the Supreme Court in Abdul Khalik, whereby there was a specific manner in which the eviction proceedings are to be carried out. It is the opinion of this court that in the case of the petitioners, if such steps were being not taken, it shall be the requirement of law that in the case of the petitioner, such steps in terms with the directions passed by the Supreme Court in Abdul Khalik should be taken. However, during the pendency of the instant writ petition, if steps already have been taken and in accordance have been taken, then there shall be no further necessity. Accordingly, the writ petition stands disposed of with the following observations and directions. The impugned notices which have been enclosed as Annexure 1 to the writ petition have become redundant in view of the directions passed by the Supreme Court in the case of Abdul Khalik Supra.
Mal.
Number 2. The respondent authorities more particularly the Forest Department, if it proposes to take any action against the petitioners, the same shall be done only by following the directions as passed by the Supreme Court in the case of Abdul Khalik Supra. Number 3. If in the meantime, during the pendency of the instant writ petition, already steps have been taken following the mandate of the directions passed by the Supreme Court in the case of Abdul Khalik, there shall be no necessity for taking further steps. Then in such circumstances, there shall be no further necessity of taking any steps in terms with Abdul Khalik Supra.
Mal. My lord, if they are going to take the Abdul Khalik recourse, my lord, then if already not taken, then that protection we will get, my lord.
You have got a protection.
My
No,
lord.
I
As
set
per-
aside the notice.
No, yes, my lord. Fresh is required, my lord. My lord.
So notice has gone.
Yes,
I've said it to be redundant.
my lord.
So now, if they have to take, they can
Yes,
only
yes,
take as per Abdul Khalik. And if that, in terms of Abdul Khalik, they have already taken,
My
then there is no requirement.
Yes, my lord.
Is what?
My lord. Another SLP is preferred, my lord. That is not yet been decided, my lord.
Fine.
Against the division bench order, my lord. Against the division bench writ appeal order, my lord.
But the Supreme Court in
My
that
lord.
Abdul Noor said,
Consider the writ appeal order also, my lord. That observation is there.
they said here that we are of the opinion that the
Yes,
learned
yes.
single judge as well as division bench of the High Court have considered all aspects of the writ petition in detail, especially do not call for any interference. So therefore,
My lord.
division bench extended the period.
Only 45 days. That is already over, my lord. Obligement.
Alright.
None appears on behalf of the applicant on call. List this matter on 25th of September. Eh? Why?
Plus, item number 13 and 14, I am appearing for petitioner, your lordships.
Yes, tell me.
Millards, the reply is awaited. The respondents have not filed any counter and reply in this matter.
It's okay, but you have filed an IA for what?
Millards, that IA copy is not available with me right now.
You are
Millards,
the
may give us.
counsel who have filed it.
Millards, the
Okay.
copy is not
Same
available.
order. 25th of September.
Please, your lordships.
With petition, the interlocutory application has come up consideration. Counsel appearing on behalf of the applicant submits that he does not have a copy of the said application. Accordingly, for the ends of justice, matter stands adjourned to be listed on 25th of September 2020. Huh? Yes, what is this item? 15. Lozima go reflect service or is complete. Service complete.
Service complete.
What is the matter about? Eviction notice
Yes, Lordship.
Chief eviction notice has been withdrawn.
withdrawn. So matter nothing
I-
remains.
No, no.
No, they
Withdrawn.
have filed an IA to that effect, lordship. That one has already been disposed of. When IA was filed, that was already been disposed of.
No, no, Lordship.
Copy of the eviction notice,
Impugn speaking order dated AI issued by so and so.
lordship.
What happened?
Lordship.
You
Instruction.
have withdrawn that.
No, no, not lordship. Not that, lordship.
Then what do you want?
Lordship, I want some time to file an affidavit, lordship.
Okay, counsel appearing on behalf of the respondent, the service. In terms with the order of the Lozima court, the service is complete. Because the Miss So-and-so appearing on behalf of the KAC submits some time, requests that some
for
time may be
respondent number 8.
granted for filing the affidavit.
I'm for
The So-and-so appears for respond number 8. And you'll file affidavit.
Yes.
Also submits that affidavit would be filed. Taking into account the above, list this matter on 28th of September 2026. In the meantime, the affidavits be filed on behalf of the respondent.
Interim, Lordship.
Interim order passed on 27/3/2026 stands extended till the next date
Publix.
Blushed.
for admission of what is this IA for?
Ma'am, your lordship, this I is for correction of address lordship
Why?
of respondent number 6, upon respondent number 6.
What is the address of respondent number 6? What is the matter, Minister?
I'm appearing for respondent numbers 4 and 5, Lordship.
What is the matter about?
Matter, they have challenged, Lordship, the freezing order.
Oh, you go there. That is the best way. Teaching for why?
Freezing, actually, Lordship, as per them, their account was freezed because they have participated in some online gaming.
Ah.
And there is one NCRP complaint regarding use of that account. And that is why, as per direction given to us by the state authority police, we have marked the account freeze. David freeze.
You go there. GRM. You go there. Not here. Standard operating procedure. Ard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. He asked for
2 and 3.
phone number 2 and 3. Mr. So-and-so for respond number 4 and 5. The petitioner herein is aggrieved the petitioner herein is petitioner herein has a current account in the Axis Bank Gwalpara branch Gwalpara bearing account number to file paragraph 4. The petitioner admittedly indulged in online trading game, namely Sati coin game, by way of its registered applications. On 18/10/2025, the petitioner was rewarded an amount of rupees 50,000, which was credited to the petitioner's SBI bank account on 18/10/2025. On the same day, various transactions were carried out by the petitioner, including a transaction of rupees 95,000 to his aforesaid to his bank account maintained with the Axis Bank. On account of a complaint on account of a complaint made by the respondent number 6, an amount of rupees 1,77,000 has been kept in lien in both the accounts of the petitioner. It is under such circumstances the petitioner has approached this court by filing the writ petition. The record reveals that the respondent number 5 has filed an affidavit in opposition, wherein it is stated that the petitioner's bank account number 9200200627499920 maintained in the Axis Bank Limited at Gwalpara branch is under debit freeze / lien mode for a total amount of rupees 1,77,000. The details of the transactions, the details have been mentioned at paragraph number 5 of the said affidavit, which is reproduced herein under. It is also mentioned that in view of these complaints, the respondent Axis Bank have complied with the directions of the respondent number 6. Does the petitioner have an account with you?
Yes,
also?
Lordship.
But you have not put any freeze.
As per direction made by the Delhi police, we have put the account under debit freeze.
He is not mentioned about that account number.
Lien mark, Lordship. It is lien, under lien.
Of how much? You are Axis Bank.
Yes, Lordship.
No, you have not done.
I have 50,000 was first 50,000 came to me, it was lien mark. Subsequently, they transferred 95,000 to Axis Bank. Axis Bank has additionally lien marked 1,77,000.
This court now finds it relevant to take note of the standard operating procedure for bracket dot NCRP bracket close dash CFC FR and CFC FRMS bracket close custody comma restoration of money and grievance redressal dated 2/1/2026 issued by the Ministry of Home Affairs. Chapter 3 of the said SOP provides a grievance redressal for mechanism. And it is also seen from a perusal thereof that the said grievance redressal mechanism provides an adequate and efficacious relief. Full stop. Considering the above, this court is of the opinion that the petitioner would be well advised to approach the branch managers of the State Bank
Actually, the prayers are not against me. It's against Axis Bank.
Against Axis
of
Bank
the
because they,
Axis Bank, wherein the petitioner's bank account have been kept on lien for an amount of rupees 1,77,000 with a complaint. Upon submission of the said complaint, the branch manager of the Axis Bank, Gwalpara branch,
Lordship.
shall initiate the procedure as stipulated in the grievance redressal mechanism mentioned in the SOP dated 2/1/2026 and take steps for bringing the grievances of the petitioner to a logical conclusion. Accordingly, the writ petition therefore stands disposed of with the following observations and directions. The petitioner is granted the liberty to approach the branch manager of the Axis Bank Gwalpara branch, wherein the petitioner's bank account, wherein the petitioner has a bank account, with a complaint as regards its, as regards his or her, his grievances. Full stop. Upon receipt of the complaint, the branch manager of the Axis Bank Gwalpara branch shall initiate the process of the grievance redressal mechanism stipulated in the SOP dated 2/1/2026. So that the petitioners' grievances can be redressed, grievances can be brought to a logical conclusion.
obliged, Lordship.
An affidavit has been filed by the respondents in this matter. We've sent the same for instructions, my lord. But in the affidavit, my lord, the affidavit has been filed with regard to two writ petitions, my lord. One writ petition was filed by this petitioner in a different case that pertains to termination of the contract. And here the issue is, my lord, withdrawal of credentials, my lord. So, my lord, a little time may be given so that we can seek proper instruction and file a rejoinder to this affidavit.
How many months? 4 months?
My lord, 2 weeks.
No, after vacation. There's no urgency. Affidavit filed on 13/8.
Right.
We are today,
21st.
7 days have gone. The learned senior counsel appearing on behalf of the petitioner, Mr. Ashram, assisted by so-and-so, submits that the petitioner would like to file an affidavit in reply to the affidavit in opposition filed by the respondent numbers 2 to 4. This matter on 39/2026. In the meantime, the reply be filed.
Obliged.
39/2026 for admission. In the meantime, the reply will be filed.
Pursuant to my lord's last order, an affidavit has been filed today, my lords.
Hmm.
Well, the matter pertains to non-compliance of a judgment and order, which my lords would find at page 20, my lords, the relevant portion, my lords. In view of the submissions made by Mr. Dekar, learned counsel for the respondent number 3 and 4, as above, this writ petition is disposed of with a direction to the respondent authorities to pay the petitioners an amount of rupees 3 crore 86 lakh 88,077 only for the supply of livestock and poultry feeds that the petitioners have made to the respondent number 3 and 4, as highlighted herein above, as expeditiously as possible, and in any case not later than 2 months from the date of receipt of a certified copy of the order. The outstanding amount payable, as recorded herein above, shall carry an interest at prevailing bank rate on and from the date the supply was made till the payment is made. This writ petition stand disposed of. Now, pursuant to filing the contempt, my lords, payment was made, but the order has not been complied, my lords.
Why?
Because, my lords, my lord has seen, it says at prevailing bank rate, my lords. Now, prevailing bank rate has not been defined. However, my lords, current rate of interest has been defined in the Interest Act, my lords. If I may kindly,
We send you to the civil court.
my lord, would kindly peruse this.
No,
The calculation, my lord.
no. Where is that order?
My lords, the order, page 20, my lord, the relevant portion which I read out. And they also say,
386,
my lord,
3 crores 86.
total, my lords.
Have
we
you got 3 crores 86 or not? For the
We receive
supply
more,
of
my lords, we receive
interest
more.
highlighted as they are not later than 2 months from the date of the receipt of the certified copy of the order. You got that?
Yeah.
Payable as recorded here means shall carry an interest at the prevailing rate on and from the date of supply was made till the date of payment.
Yes, yes.
Now,
Now, my lords, my lord, may kindly peruse the chart, my lord. Now
No.
they have added an interest at the rate of 2.70, my lords. Now the judgment clearly says prevailing bank rate. Now, prevailing bank rate, that phrase has not been defined anywhere, but current rate of interest is defined in the Interest Act, my lords.
Mm.
And even, my lord is aware, my lords, section 34, the proviso says, my lords, in commercial transaction, it can be more than 6%. Now, the Interest Act says, my lords, if I may kindly read it out, my lords, current rate of interest, section 2B. Current rate of interest means the highest of the maximum rates at which interest may be paid on different dates of deposits other than those maintained in savings
we
account.
paid
That's it.
IBP is also interest.
Interest also paid. Lordship,
2%,
that was
2%, my
calculated.
lords, 2%.
Got it? We close it.
That's it.
In that case, my lords, I'll pray, Lordship would give me liberty to assail the action, my lords, because
Where?
Where?
Yeah,
not here, my lord, not here.
Where?
My lord, by preferring a separate writ
you
petition.
return that amount of 32
No,
lakhs.
only on the interest.
First deposit the interest amount to the court, then we can
My lord,
deposit that. We'll consider
contempt
whether
proceedings
it
between
is,
the,
whether you deposit that amount of 32 lakhs. Think that is.
no, I'm just submitting in terms of the judgment, my lord. Judgment says current. rate of-
Judgment says prevailing.
Prevailing.
And this court cannot go beyond that. Prevailing is maybe the savings account.
That has been clearly barred by the Interest Act, my lord. It cannot be the savings account.
Interest Act will not apply in the High Court 226.
That's it.
Nothing to do unless the court specifies. Nothing doing. We
Lordship would give me
one thing
liberty to assail it.
we ask you to return that amount in that
No,
order.
Lordship would just give me liberty to assail it in proper forum of law,
No,
wherever,
You
my lord,
don't
civil
get a
court.
right on the basis of an order.
Yes, yes.
Right has to flow from an action, not from the basis of an order. You are asking for compliance, and we say that I consider it to be complete compliance. Matter over. The heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so appears for the respondent number.
1 and 2.
So-and-so, so-and-so, and so-and-so. The present contempt application has been filed alleging willful and deliberate violation to the order dated 30/11/2022 passed in WPC number 1594/2022, whereby the learned coordinate bench of this court issued a direction upon the respondent authorities to pay to the petitioner an amount of rupees 3,86,88,077 within a period of 2 months from the date of receipt of the certified copy of the order. The learned coordinate bench also mentioned that the outstanding amount payable as recorded herein above shall carry an interest at the prevailing bank rate on and from the date of supply was made till the date of payment is made. The materials on record show that the petitioner have already been paid the amount of rupees
As per our
3
calculation,
lakhs, 3,86,88,077 after making necessary deductions.
my lord, I'll come to that, my lord. They have deducted 10 lakhs out of TDS, my lord. That has not been deposited in my TDS account, my lord. And it has anyways lapsed, my lord. TDS has to be deposited in the same financial year. Even that has not been compliant. They have deducted the TDS to the tune of 10 lakhs odd, but that has not been deposited in the account, my lord. There's no TDS certificate given, my lord.
TDS certificate nowadays is not given.
Not required. They have not deposited that TDS amount.
If it is not deposited, they will show. No? They say that they have said that. On the materials on record, it is seen that the petitioner have been paid an amount of rupees, how much?
4 crore 19 lakhs.
9,778.
4 crores 19 lakhs
9,000.
9,778
Yes.
Page 43.
after deducting an amount of rupees 8 lakhs 55,302 on account of deduction of tax under the Income Tax Act. The said amount of rupees 4 crores 19 lakhs 9,788. The total amount of rupees 4 crores 27 lakhs 60. The materials on record show that the petitioner was found where is the payment of interest?
It's 2.70%, man.
Where, no, where?
We have calculated, that's not.
In paragraph 4, Lordship.
Affidavit of descent, right?
Hmm? When were the payments made?
Different dates, my lords.
When?
They have appended the vouchers, my lords. The last payment was made on 6. I have the dates, my lord.
Is here.
I have prepared a chart, my lord.
But
The exact
all were paid on something in 2024 and 25.
Lordship.
4 different dates, my lord. 5 different dates. I've mentioned it in
The
the chart.
materials on record show that During the pendency of the contempt proceedings, the petitioner have been paid a total amount of rupees 4 crores 27 lakh 65,080.
No,
That was a sanctioned amount, Lordship.
4 crore 19 lakhs 9,700.
You don't disturb.
I'm so sorry.
Take your seat.
Well,
I know what to write. We impose a cost of 1 lakh upon you. Paid an amount of rupees 4 crores 27 lakh 65,080, which is inclusive of the amount of rupees 3 crores 86 lakhs 88,077, along with the interest of rupees 40 lakhs 77,003. The interest being calculated at the rate of 2.7% per annum. Out of the said amount of rupees, at the time of disbursing the said amount, an amount of rupees 8 lakhs 55,302 have been deducted at source, and the resultant payment which have been disbursed to the petitioner is rupees 4 crores 19 lakhs 9,788.
778.
778. The details of such payment can be seen from the affidavit so filed by the respondent number 2, respondent number 3, as well as an instruction dated 28/2026 placed by Mr. Manoj Bhagavati, learned counsel for the respondent number 2.
1 and 2, Lordship.
1 and 2. The instruction dated 28/2026 is kept on record and marked with the letter X. The details of the payment is in the form of a table is given here in under. Right. From the above, Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner, submitted that the rate of interest at which the petitioner had been paid is a meager 2.7% and should be the prevailing should be the rate of interest in terms with the fixed deposits. In the opinion of this court, the order dated 30/11/2022 passed in WPC number 1594/2022 merely mentioned about prevailing bank rate without specifying as to whether the said amount should be in terms with the should be the should be the banking rate for savings bank or for fixed deposits. Under such circumstances, it is the opinion of this court. In view of the above, the payments so made and the details given herein above, opinion of this court is amounts to sufficient compliance to the order dated 30/11/2022 passed in WPC number 1594/2022, for which the contempt proceeding stands dropped. Martin.
EDS has not been deposited. That may be kindly mentioned my submission. Deeply relevant.
But I have got the document, my lord. I have it.
Now let's see section 21A. Of the Registration Act. Is there not? If you read section 21A, there's a requirement of certain compliance is okay. You are required to complete the entire formality within 30 days. Okay. But then also, you can ask if there is any deficiency.
Gotcha.
Why didn't you ask about the deficiency and cancelling this application just for the sake of doing it?
In
No, you see, a person who has been fighting all this while for the 3 years, this is not how you do it.
Kindly,
No, I'm not on that.
for a moment, take.
What are the two grounds? No, I remember the case.
Gotcha.
There are two grounds. One is the non-encumbrance certificate. Did you ask him to produce it?
What I'm trying to submit, my lord.
No, you don't try to convince me on the other thing. My question is, have you seen 21A? The requirement is within 30 days you have to give it. But if it is not possible, you can give a reason. There might be some insufficient documents. Because what you are doing out here appears to be that it is in one way or the other you are trying to violate the court's order.
Well, paragraph 18 shows that when the application was sent to the application is forwarded to circle officer by Lat Mandal, it was on 13th of February 2025. It is in online portal. The online portal also shows that rejected by circle officer on 27 to 2025. And reason that application is rejected by circle officer, as per report submitted by LRA, the NOC may not be accepted. That is the remark in the online portal. It was shown. The Honorable Court has noted in paragraph 18 of the judgment.
It is not a good reason.
Reason is not there.
Therefore, my lord, in
There's
fact,
no good reason.
lordship, my lord, in fact, what I am trying to submit, my lord, that this online status is available, my lord. It is
Mr.
available to
Mr. Nath,
the
you see,
petitioner.
there are two ways out.
Lordship, lordship.
If you want to be very technical, we can be very technical. Ask your circle officer. If he wants to be very technical, we can also be very technical. Stick to this 2 months or to 1 month or 2 months, which is directed. And then put him. Whatever the appellate court does, I'm not least bothered with that. Put him 1 day or 10 days also, put him behind the bars, then we will know how it is to be done. But on the other hand, what is required is, you could have very well asked him, he has been fighting all the while, all these things for that. He's only asking the non-encumbrance certificate. Is it a big problem to get the non-encumbrance certificate? Or is it just because of the fact that he didn't like the face of the petitioner? It seems something to that effect.
But in the month of February.
No, first and foremost, you have to
F-
complete within a period of 30 days. Did you inform if there is a deficiency out there, you have to inform? We asked the circle officer to be present
Well,
and the DC. No.
Online portal
We
shows
take
he
it
can
that
very well.
you see, he has delegated.
Lordship.
You see that when it is being delegated by the deputy commissioner, the principal officer is also equally responsible.
Kindly see, my lord.
I will initiate a contempt proceedings against them, ask them to be there, then initiate proceedings.
In the month of February,
No.
it is made known to him.
No.
He has not yet submitted those documents.
Where is it mentioned
Well,
in your order? No, where is it mentioned in your order?
No, no, in this petition, we have filed the affidavit in the month of February, in February of this year, and bringing the order to his knowledge. Now, till date, he has not filed. He has not
What?
not submitted the document.
You have rejected it.
Malad,
You have, I have to understand, you have rejected it.
the reason
You
is,
should have asked him, kindly produce this document. That's enough.
the reason is made known to him. What he has done thereafter. Kindly appreciate that. Malad.
No. First of all, you have rejected it.
Lordship.
So if you have rejected his application, then in that case, what happened? In view of the reason, the other are hereby rejected. Now he has to go for, and see, the applicants are advised to apply again and go through the entire ordeal. See the order, impugn order.
Lordship. This speaking order is to be passed.
You do
Speaking
one
order-
thing. I am not on
Lordship,
these
Lordship,
speaking orders. We are not going to totally disregarding.
Lordship,
You submit this,
let him
the
submit.
reason for discrepancy.
My lord, kindly 1 minute, may I be allowed? Number one, since the introduction of NOC system, and as on today itself, it is issued by Deputy Commissioner through his Deputy ADC, my lord. See the last 4 orders, the NOC, my lord.
No. You see, the designated authority is the circle officer.
My lord, not a single NOC is issued as per instruction by circle officer till date, my lord.
It's okay.
All
No,
are
no,
till
no,
date.
no,
it is
the-
ADC, my
we are not concerned on that. We are concerned whether who issues the NOC. I'm not the concerned. Here, and if there was a direction to approach this particular authority, the designated government servant. That was the direction passed by the court. Here they say that after 11/11/2022, 22,
22.
in the year 2024, this particular person was appointed, the circle officer had been appointed as the designated public government servant. Okay. So therefore, the application should have been disposed of by him because the direction is there.
My lord,
You want the NOC or not?
want, my lord.
Okay. Now, why there is this discrepancy? It is found that the name of the first party, S. Ahmed, which is mentioned in the affidavit, does not match with the buyer and seller. Why?
Correct, my lord. Let me, my lord, kindly answer it. Number one, my lord, till the last officer came, I asked them.
No, Mr. Talukdar, come to the point. If I am trying to help you,
Yes, my lord.
come
Yes,
to the
my
point.
lord, your lord.
Why there is this discrepancy?
My lord, this is, my lord, how happened last time, my submission, my lord, as per instruction, my lord. Till the last DC came to Korimganj, it was going on like this. Anyone can purchase the, my lord, the stamp. It was going on. Thousands of, if your lordship call for records, it will be proved that at last, only after the last officer came, he wanted that. Yes, it should be in the same name, my lord. Before that, thousands and thousands and thousands why are going on like this, my lord. And regarding encumbrance, my lord, he is absolutely incorrect, my lord.
No. What is, you see, I'll come to the point. It is found that the name of the first party S. Ahmed, which is mentioned in the affidavit, does not match with the buyer and seller.
Yes, my
Meaning by
Yes, that I am saying, my lord. Before the last officer came, it was going on. Anybody can purchase, and it is more purchased by
purchase what?
purchased by Mohri, by the stamp, my lord. The non-judicial stamp, my lord.
You mean to say that the affidavit stamp which
Stamp.
is there,
Yes, my lord.
which is being purchased, the affidavit stamp normally bears a name who purchases
Yes, my lord.
on the back side.
Yes, my lord.
In this case, it was purchased by
Stamp,
Mr.
my lord.
S. Ahmed.
Yes, Ahmed. Yes.
But the affidavit was done by the buyer and seller.
Yes, my lord.
That is the reason.
Yes, my
You submit a fresh affidavit purchasing by yourself.
lord. The number. Yes, my lord. That is okay, my lord. Okay, my lord.
Second is as regard non-encumbrance.
That is not correct, my lord. Absolutely incorrect. Kindly see the, my lord.
Do you have the non-encumbrance certificate?
My lord, not required, my lord. Not issue, neither issue, not required. It is the substitution is there, my lord. Substitute document is there, my lord. Kindly have a look, my lord. Kindly have a look at the page of their affidavit, my lord. Their affidavit, my lord. Kindly turn to page, my lord. The affidavit at page, my lord. I'm 35. I'm showing your lordships. There are 3 affidavits. They have a next, my lord. Kindly have a look. What is the system is going on? Page, kindly page 43, my lord. I turn to then page 44, the operative part, my lord. Page 44, page 43 is an affidavit, my lord. And 44, kindly see the operative part of the last line of the second paragraph, my lord. The my lord, land after there is neither any objection against transfer of nor any court case is in respect of the said land. After transferring the said land, we will not be rendered landless. The said land is free from all sorts of encumbrances. By this system of affidavit, all deeds are going on, my lord.
Mr. Talukdar, can you produce the non-encumbrance certificate or not?
My lord, if my lord,
Do you know what is a non-encumbrance certificate or not?
my lord, we can, my lord.
Are you aware what is a non-encumbrance certificate or not?
Yes, my lord, my lord.
Produce that. That's all. You produce it.
My only submission is that, my lord, kindly, my lord, that I will.
Mr. Talukdar, the thing is, when there is a requirement of a non-encumbrance certificate, you have to submit the non-encumbrance certificate. What is the practice followed out there? What is not the practice followed out there? I'm not concerned. The law is what are the documents mentioned, you have to submit.
My lord.
Although the affidavit on which they should have rejected should not have been rejected at all. The whatever may be, that affidavit could have been very well. But anyways, you purchase a new affidavit, stamp paper and submit an affidavit. One. Second is the non-encumbrance certificate. You produce a non-encumbrance certificate. Non-encumbrance certificate is what? That this particular
Yes, my lord. Free from any loan or any mortgage or anything from any kind of
the certificate.
liability, my lord.
The certificate is given by the particular deputy commissioner. That it is free from all encumbrances. But Mr. Nath, let me ask you one thing. Till when does the certificate is there in Kamrup Metro? Is it up-to-date certificate given? Are you aware of it?
Non-encumbrance not
It is never given up to date because they cannot.
at least 3-4 years
No,
they cannot.
it is given around till I started became a judge. It was till 2009 or 7, 10. These certificates are given. Thereafter, they don't give it because they don't have the records.
Not nowadays, but possibly nowadays up to 21, 22 they are giving.
Then, what is the meaning of that non-encumbrance then?
Even if it is a requirement, let him give.
Okay.
Let him give.
I am only singled out by him, my lord. Only I am singled out. I need it now. After filing the case, my lord.
What?
Regarding non-encumbrance, my lord, they raised it only in case of me now only.
No, it is not so, Mr. Talukdar. It is everywhere here.
But in
You are primarily practicing in the High Court, may not be knowing it. But if you go for a sale deed, there is a requirement of a non-encumbrance. They also ask for a form. What is the name? The Form 50, na?
Form 50.
Form 50 is
No
being
lit-
asked,
no
that whether
litigation.
there is any litigation out there.
Litigations, my lord.
These are requirements which are there.
In
Cannot be.
my lord, in
And merely because of the fact that both of you have wanted to do it out there, that is a different thing. But it is the requirement.
yes,
That there has to be a non-encumbrance, there has to be so and so.
legal requirement, my lord.
It is a requirement.
But there it is not required, only affidavit is sufficient, my lord.
Now tell me, Mr. Who purchased the stamp here in this affidavit?
Well, kindly come to.
No, kindly come. No, not that.
Page
The
43.
no, the affidavit which you have filed here in the High Court. Who had purchased that stamp? Did the Deputy Commissioner purchase it? No. Did the Deputy Commissioner purchase it? No. So therefore, these are absolutely these type of objections should not be taken. At the end of the day, who is to you are to only collect the duty.
The e-stamp, page 43. kindly
Same
see.
understood.
Page 43, kindly see. First.
This is the court fee.
No. First.
Now,
party-
this is the court fee which you have done it.
Not your lordship.
Where is it mentioned in your thing that it has to be purchased by him?
First party's name is shown in page 43. Kindly come to 43, my lord. It is not in the back side, it is in the front side. Page 43, first party, second party.
Hmm.
First party S. Ahmed.
Hmm.
Stamp paid by S. Ahmed.
First party,
S. Ahmed. Page 43.
second party, yes, I mean.
Second party not applicable. S. Ahmed has paid the stamp duty. What is the difficulty in?
Do one thing. You are a collector, na? Cancel this affidavit and give him the 100 rupees back to I submit. Because it's policy 50 of the Indian Stamp Act. Return it. If this affidavit is of no use, you are the stamp duty. You are the collector. This is the collector.
Well, he has taken the stamp paper.
No.
and
The
typed
moment
it
an
wrongly.
affidavit is not done, it has to be in that manner.
He has done the wrong after purchasing the document. He has done the wrong, my lord.
Anyways,
Not.
you submit a fresh here, non-encumbrance within 30 days. We'll take it up later on. And we say that this is not a speaking order in term sheet. Heard Mr. A.K. Talukdar, the learned counsel appearing on behalf of the petitioner. Mr. B. Nath, who appears on behalf of the respondent numbers 1 and 2. The present application has been filed alleging willful and deliberate violation to the judgment dated 5/5/2025 passed in WPC number 1493/2025, whereby there was a direction upon the designated public servant to pass a speaking order within a period of 3 weeks from the date of submission of a copy of the order by the petitioner to the office of the designated public servant. The copy of the order was served upon the district register cum district commissioner, who forwarded it through the additional district commissioner to the sub-register Sri Bhumi, as well as to the circle officer Sri Bhumi, for necessary compliance on 19/5/2025. An undated speaking order was passed by the circle officer Sri Bhumi and forwarded to the additional district commissioner by the communication dated 2nd of February 2026. By this speaking order, the petitioner's application was rejected on two grounds. One, the first being that the affidavit was purchased, the stamp paper on which the affidavit was submitted by the petitioners was purchased by one S. Ahmed, who has been also shown as the first party. The second ground is non-submission of the non-encumbrance certificate. Mr. A.K. Talukdar, the learned counsel appearing on behalf of the petitioner, submitted that the said rejection is nothing but an overreach to the judgment and order passed by this court dated 5/5/2025 in WPC number so and so. Inasmuch as it is the practice followed as to in terms with the practice followed, the affidavit was duly submitted and there is no requirement for a non-encumbrance certificate in view of the contents of the affidavit itself. This court finds it relevant to take note of Section 21A of the Registration Act 1908 insofar the same is applicable to the state of Assam. And a perusal thereof would show that when there is a deficiency, the same can be very well informed to the parties for due correction before a rejection. This court inquired with Mr. A.K. Talukdar as to whether the petitioner would be able to provide a fresh affidavit on a stamp paper purchased by one of the petitioners and the non-encumbrance certificate. The learned counsel submitted that the same can be done. Stop. Liberty is given to the petitioners to submit a fresh affidavit on a stamp paper purchased by the petitioners, whose name or the name of one with the name of one of the petitioners being mentioned as the first party in the said affidavit stamp paper, and also to submit the land encumbrance certificate to the circle officer Sri Bhumi Sodar Circle within 30 days. List this matter again on 5th of October 2026 for an update. It is observed that upon submission of such affidavit as well as the non-encumbrance certificate, the circle officer Sri Bhumi Sodar Circle shall take it up, shall pass a speaking order and place the same before this court.
Well, I have a small submission, Madam. Well, by the earlier speaking order, they were advised to apply again. Lordship may kindly consider that also. They were advised to apply again along with necessary documents. Lordship may consider that.
This court makes it very clear that the said non-encumbrance certificate as well as the fresh affidavit, which this court permits the petitioner to be submitted to the circular officer Sri Bhumi Sodar Circle with a period of 30 days from today. shall be taken on record by the circle officer Sri Bhumi in respect to the earlier NOC application which have been filed and was rejected in the speaking by the undated speaking order. The circle officer thereupon shall process the said and pass a speaking order and place and provide an update on the next date. Mr. Dubey, Mr. Rahul, Ms. Devi, I won't take up your matter today because time would not permit. We'll have it on next Tuesday. Let's see how many matters I have next. Next Tuesday will be what?
25th.
Not Tuesday. Next Thursday, 2 up 27th. Huh? Today it would not be possible to do it. Otherwise, there is one day you can wait. First of September. I have only one matter listed.
On the
Huh?
1st of September, here my lord is soon to be a holiday. The calendar shows it's a holiday.
First September is a holiday. Oh, somebody has a, therefore one matter somebody has listed. Okay. It's okay. Then we'll have it on
25th.
27th. 27th at 2 p.m.
My lord.
Hey, item 2 asil no hai, but
The interim order needs to be extended.
interim order shall continue till the next date.
Deeply applied.
Respondent number 2 has filed affidavit. Yesterday I received the copy, my lord.
You have filed?
Yes, my lord, it is on record, my lord.
What is your stand?
My lord,
Kammala.
Assammala. If lordship may be pleased to come to my lord page 26, my lord, running page 26. My affidavit, my lord, paragraph 4.
Start from 26 or 26.
26.
Now what is to be done?
Here, my lord, there is a dispute, my lord, apparently between the writ petitioner and my lord, one another person. Subsequently, my lord, we have stated that paragraph 9 of our affidavit, my lord.
This Assamala is done under the right to fair.
Right to fair compensation.
Now, not recently, the amendment which has been made to the
2000
Right to Fair Compensation Act.
Assam amendment.
Where is that?
That
No, Assam amendment. We post this matter on 25th. 25th, there are other 2 matters on land.
Yes, that my lord.
Which
They
one
have
is there?
questioned- Yes.
One is
Yes,
pertaining to
I'm having it.
There are two way, yes, that matter is there. Where, as to whether regarding the Mr. S. Kotoki's matter is there.
Yes, that is WPC 4321 of 2025.
Hmm.
And another matter, my lord.
There are two matters
Yes, yes, that,
which I fixed it on 25th.
yes, that is my
One is pertaining, these are pertaining to
land acquisition for the purpose of my lord installation of solar power project by APDCL and Dhubri.
no, that is there. But there is an important issue involved wherein you therefore say that the Assam right to fair compensation has been brought within the fold of Chapter 4, so Schedule 4. And as such, it is protected. It is not protected in that regard. The Act is not protected. It is not, it doesn't have the same thing like the 10th schedule to the Constitution, wherein you, the moment you put it, you can take it out. But that is another thing. There is a challenge to that. Hey, এইখন তললে আহকচোন। সেইদিনা মই আপোনাক দিছিলো এইখন ৰাখিবলৈ মোৰ কাৰণে তলত ওপৰলৈ। Kindly see this 23A.
23A.
Notwithstanding anything contained in section, if at any stage the collector is satisfied that all persons interested in who appeared before him have agreed in writing in the matter to be included in the award and in the form of real rules, he may, without making any further inquiry, make an award. So this is the concept. The
Consent award.
determination of shall not be in any effect of the determination of any other. Notwithstanding anything contained, it is not required. So this is, in fact, Assam Mala, though you say to spring from 46,
Yes,
but in essentially it will come under 23A, and then kindly see the 30A.
yes.
This is 30A.
38.
Notwithstanding anything contained in the principal act or any other law wherever it appears to the state government that an area is required for public purpose, the state government or its authorized may enter into the land with the willing so and so, and the area so and so. Now this is it.
Yes.
30A2.
Yes.
This is Asamala.
This is, in fact, Assam Mala is a flagship project. It is a flagship project of the PWD for speedy acquisition of land. If otherwise.
Understood. So therefore, now it will come under 38.2.
Absolutely. Yeah. And in those writ petition, I have the order. If I may read it, my lord, paragraph 2. That is my lord's order dated 3rd of August 2026. Passed in one of those writ petition. Paragraph 2, the present writ petition has been filed challenging the action of the respondent authorities to initiate proceedings for requisition of land under the provisions of 1964 Act. The lands have been specifically described in paragraph 3 of the writ petition and for consideration so and so. Thus, paragraph 4, the issue involved as aforesaid is as to whether the respondent authorities could have exercised jurisdiction under the Act of 64 to requisition the land and then acquire the land, or respondent authorities could have only exercised jurisdiction in terms of the 2013 Act. Now, since we are mixing up both the acts, the entire exercise is being done in tandem with the 1964 Act, but we say that the compensation that you will be getting would be in terms of 2013 Act. Now, whether that is permissible or not.
No, now I remember. Mr. Kotoki's case is to the effect that you see, you have gone for, you knew that this land is to be acquired. So why did you go for requisition? And at the time of requisition, there was no Form A publication. That is one. Then you have gone to acquisition. Acquisition not done.
There, my lord, the district commissioner has filed affidavit, which, if I remember, my lord, remotely, they say, my lord, that the acquisition has been completed. But then, my lord, perhaps an affidavit will be required to be filed by the revenue department. That
But
will be.
there is an interesting judgment passed by the Supreme Court in the case of K. Venkataswamy. I think you must have read it. 2026 SCC Online, SC 1487. There it is in the context of 3H4. But the observation out there is this. Recognizing, however, that disputes of more complex nature. You see what it says? Under subsection 2, the competent authority is under a statutory obligation to disburse the compensation to the person or persons entitled thereto. Where rival claims are raised, subsection 2 casts a further duty upon the competent authority to determine in its opinion the persons entitled to receive the compensation and the extent of their respective shares. Recognizing, however, that the disputes of more complex nature, Parliament enacted subsection 4. It provides that where dispute arises regarding apportionment of the compensation or regarding the person to whom the compensation or any part thereof is payable, the competent authority shall refer the dispute to the principal civil court. Now, an interesting thing in this particular thing is this. The jurisdiction exercised by the reference court, why I am saying about they have a case, under section 3H4 is therefore wide enough to incidentally determine the question of title insofar as such determination is necessary for deciding the person entitled to compensation arising out of the acquisition. So therefore, now here in this case, there are disputes. So you cannot go ahead, there cannot be an asamala to that effect. You have to go for an acquisition.
That is what is specifically spelled out in my affidavit also.
Yes, you have to go for an acquisition. And if you
Absolutely.
go for an acquisition, if there are disputes out there, you have to refer, this is in the mandate of section 31 of the old act, by which irrespective of anybody making a reference also, the dispute has to be sent by the collector. So this is how it is. So we take it up on 25th and finish it matter. Because nobody can get it unless when there is a dispute. But interesting aspect of this judgment is the reference court incidentally can decide the title. So therefore, the question of going into the suit, who is entitled is not necessary.
This is just like, my lord, I find it to be somewhat perimeter with the provisions of, my lord, the some prohibition of land grabbing act. Yeah, my lord, prima facie, my lord, the special tribunal has the power to decide it without going into the nitty-gritties of a regular civil suit.
Now, in fact, in these cases also, we can bring the reference to this proposition of law which has been settled by the Supreme Court, that the reference court can incidentally decide for the purpose of determination of the compensation.
Yes.
But that would only happen at the time when an acquisition is there. Now, by way of a Assam Malai, it cannot happen.
So Asamala is absolutely, my lord, there has to be consensus ad idem. That is the bottom line. If there is no consensus ad idem, my lord, no point in going forward.
So, as per your affidavit, have you forgone this thing as regards the petitioners and the respondents?
Yes, my lord, that is spelled out, my lord. If lordship may be pleased to
wait.
Paragraph 9 onwards, my lord. Paragraph 9, page 28. Regarding amicable partition among the legal heirs of late Habib Ali Mazhar Bhuya and the petitioner's alleged exclusive possession.
Which person? Page?
Page 28, paragraph 9 of the affidavit, my lord.
Page 28 is paragraph 8.
Then, my lord, I'm sorry, my lord, some
28 for 9.
Designation.
Filed by whom?
Filed by, my lord, the additional chief secretary.
Respondent 2.
Therefore, it is paragraph 9. Paragraph 9 that with regard to paragraph 5.
Yes.
So and so.
Regarding amicable
amicable partition amongst the legal heirs and so are denied to the extent they are contrary to the revenue. During the field verification conducted and so found in possession and so, the direct purchase was processed strictly on the basis of available revenue records fixed so. That with regard to that, the land was procured under so relating to land acquisition through direct purchase by way of a negotiated sale for infrastructure, including the Assam and the executing authority area, and payment is released only after an agreement is executed by the person recognized as the landowner in accordance here. The procedure was carried out strictly in terms with that. Then the position is constantly.
Paragraph 11 will, my lord, assume significance.
I think the person entitled or portion are not finally decided by the collector, but referable to the land acquisition rehabilitation area under 64.
paragraph 11 speaks about, my lord, disputes, my lord.
No,
in the
understood, but therefore my question out here is very specific, that if you have acquired from him on the basis of his land records by way of a direct purchase, if he is not agreeable to the amount, tomorrow what happens?
Yes.
Tomorrow, in the proceedings, when you are transferring it to the civil court to decide, and the civil court comes that he has no business, it is he, then what happens?
Then, my lord, this amount is not disbursed. Therefore, it is specifically written in paragraph 13.
What does he say?
Paragraph 13, my lord. The deponent respectfully submitted a compensation in respect of the petitioner's recorded share of land covered by DAG number 421 has already been disbursed to his bank account as per revenue records and however, compensation in respect of Abdul Kalam Mazar Bhuya, Karim Mazar Bhuya and Sahana Begum Bar Bhuya has not yet been disbursed as objection has been filed by the petitioner. In view of the Honorable High Court's order dated so directing the Deputy Commissioner not to release the amount either to respondents 7 and 8 in respect of the withheld amount will be dealt with strictly in accordance with the law and subsequent directions of this Honorable Court.
So therefore, I understand that, but the problem lies is, if it is found tomorrow that he is the owner, he is not the owner in the proceedings, then can there be would it be construed to be acquisition by way of that? No. So therefore, there is no agreement.
There has to be agreement, yes.
So therefore, there has to be an award also. Now, if you see, interestingly, it's section 4,
Yes.
clause 4 of that direct purchase thing,
Yes.
it categorically mentions that after the agreement is made a part of the award.
Yes.
So therefore, there has to be an award. Have you passed the award?
Here, my lord, per se, it doesn't say, my lord, that the
it
award
doesn't
has
say
been
so.
passed. Yes. Per se, it doesn't speak out of it. Because the-
Therefore, yes, Mr. Laskar.
In the read petition, my lordship, there is not a single sentence regarding the DAG number 421, my lordship. Not a single sentence, my lordship. That in the prayer portion, this DAG number 41 and lots of other DAG has been written. The dispute may be, my lordship, para 9 may be seen. Here, three names, also the affidavit in opposition, my lordship. There are three persons, my lordship. They are also not parties with whom he has disputed. Anwar Hussain Mazhar Bhuiya, Sabir Ahmed Mazhar Bhuiya, they were found to be there in possession, my lordship. And here, the petitioner has made us parties, my lordship. But in the read petition, my lordship, our compensation, our claim is DAG number 421. But nothing is there in the any sentence regarding 421 DAG number, my lordship. In the prayer, stay order has been sought, my lordship, in 421 and 420 and others, my lordship. And he has taken his share already, my lordship. Kindly see the read petition, my lordship, and prayer portion, my lordship. Compensation amount in respect of covered number, DAG number 437, 438, 441, 441 and 421. But in the read petition, my lordship, only 420, my lordship. Regarding 420 DAG number, it is written. And in respect of 420, my lordship, three names has come out from the affidavit in opposition. They are not parties. So we have been made parties only for the purpose of harassment, my lordship. He has taken his share out of that.
Not my lord.
As per affidavit para 13, he has taken his share. And only to stall our share, my lordship, he has made us party, my lord.
Since there is dispute pending, my lord, regarding the ownership as it is here.
Sentence has been written.
Wait. Where is your dispute?
My lord, there is a pending dispute. My lord, in the rejoinder, I had a prayer to make for rejoinder filing, my lord, before this. Because some mistake.
First of all, that is one. And how are you claiming right over this land?
I've also stated in the writ petition, my lord, because there's a.
No. Writ petition statement would not do. How are you claiming ownership of these lands?
Because I have the, my lord, right and title interest of this land, my lord.
How?
From inheritance right, my lord.
So there must be some patta.
Yes, my lord.
Where is that?
My lord, initially I had to pray, my lord, for filing rejoinder.
My lord, by rejoinder, you cannot bring those documents. Your writ petition is otherwise not maintainable without those documents. Prima facie, there is no title.
In the writ petition, he has only annexed, my lord, the revenue receipt. which
And,
that is not-
and in the revenue receipt, it is only shown from whom it is received.
Yes.
It,
Annex
it
one-
does not even show that it is received from the owner.
Yes.
My lord, I have
We
the
dismiss
document.
your
my lord.
petition.
My lord, I have the document on, only one date
No.
will be given, my lord.
You have not enclosed any document out here to show that you are the owner.
My lord, I'm filing rejoinder in it,
No,
my
you
lord.
can't file a agenda like this. Your
Because
initiation of the
yesterday I
notice-
received the affidavit, my lord, from them.
Okay, would not look into the affidavit.
He is the dominant lity, my lord. He will have to lay a prima facie case.
In PR person, he added, my lord, see all those dark numbers.
We dismiss your petition.
My lord, one prayer, my lord. Because since I have the right, in the lower court also case pending regarding the owner titleship in between us, my lord.
So go to the lower court.
My lord, we are
Why
ready.
should you
If
be
this
here?
honorable court director to file them, we are ready, my lord.
No, I am not on that. My question is, if you want to go to the lower court, you have been to the lower court, be there. But you,
My lord, that is pending there.
Mr. Barpuzari, now I remember a case. His case squarely comes within the ambit of, there is a principle laid down by the Supreme Court, by the House of Lords in a judgment called Henderson versus Henderson, 1843. This is a very important principle, and it is on the basis of that we have the explanation 7 to section 11.
Yes, yes, yes.
It is on the basis of Henderson and Henderson, this principle was there, that you cannot keep on going to various courts, ask for various reliefs, and you have it is on the basis of your doctrine of election. And having not been successful there, you cannot come here like this. Your case squarely comes within that Henderson versus Henderson.
My lord, para 5, my lord.
Yeah, forget about that. I think we dismiss it.
My lord, para 5, may I read, my lord?
No case made out.
My lord, in para 5, kindly.
Oh, no
Let
case.
me read, my lord, para 5, my lord.
In fact, that judgment has been very well relied upon in a recent judgment of Justice Partiwala relating to contempt matter on the aspect pertaining to abuse of the process of the court. It's a recent judgment of Justice Partiwala on where he has referred to the judgment of Henderson and Henderson. It is a judgment of the Supreme Court of the House of Lords in 1843. And you find that principle in explanation 7 to here.
Yes, ma'am.
Okay, the counsel appearing on behalf of in pursuance to the order passed by this court on 15/7/2026. The respondent number 2 as well as the respondent number 7 and 8 have filed their affidavit in opposition. Respondent number 2 had filed an affidavit in opposition. The learned counsel appearing on behalf of the petitioner submits that he would like to file a reply. This court finds it very pertinent to observe that in the instant writ petition, though the petitioner have claimed that he has right over the various plots of land, contained in tag numbers 437, 438, 440, 441, 421 of second RS Patta number 108. Of village Matizuri,
Yes,
under Moza Matizuri in the district of Hailakandi. But there is no document which has been placed on record which should show that the petitioner has any semblance of right over the land. Well settled by the judgment of the Supreme Court in the case of so and so versus so and so, reported in 1988, 4 SCC, page 534. That when a writ petition or a counter affidavit is filed, there is a requirement of producing the necessary documentary evidence in support of the contents of the writ petition. The learned counsel appearing on behalf of the petitioner submits that the petitioner may be granted an opportunity to bring on record those documents by filing an additional affidavit, apart from filing the rejoinder reply. Full stop. Accordingly, list this matter on 28th of August 2026. In the meantime, the reply be filed. Interim order passed earlier shall continue till the next day. Not 28 is too early. Aji ki, subis na? 21, no.
21.
We'll have it on 7th of September.
He has taken his share.
We will look into it.
Okay, we will submit, my lord. before-
We'll look into it.
We have filed our rejoinder, my lord.
I have seen it.
53.
Yes, what has happened? What is your instruction?
Yes, Lordship, one instruction we have received, Lordship. As per this instruction, Lordship, the settlement was till date not settled with the respondent number 4, Lordship.
Okay. So, till date, no award or not to award the so and so for the respondent if not already. So the interim order is there. Now, what do you say about the other documents?
Other documents we have to verify, Lordship. For that purpose, Lordship, we'll file affidavit, Lordship.
Okay.
My lord, I have received the instruction that the private respondent is running the market.
Now we say,
Yes.
don't worry.
Yes, my lord, yes.
No, it's okay.
And we have taken dusty service.
Lordship, may I place the instruction?
Ms. N. Chaudhary, the learned standing out, submits that in pursuance to the impugned communication dated
29/7.
29/7/2026 issued by the
Respondent number 2, my lord.
respondent number 2. There has been no awarding of the settlement pertaining to Masbat Weekly Open Market in favor of the respondent number 4. Under such circumstances, there shall be no, this court makes it clear that the respondent number 1, 2, and 3 shall not award the Masbat Weekly Open Market to the respondent number 4 till the next date. The communication issued by the respondent number 2, counsel has it
Yes, my lord.
dated 21/8/2026 is kept on record and marked with the letter X. Miss N. Chaudhary, the learned counsel appearing on learned standing counsel appearing on behalf of the BTC, 6 for how much time?
3 weeks time.
3 weeks time for filing the affidavit. Full stop. List this matter again on 23rd of September 2026. This court further observes that in addition to the interim order so passed on 14/8/2026, to the effect that there shall be no award of the Masbat Weekly Open Market to the respondent number 4 by the respondent numbers 1, 2, and 3. The respondent number 1, 2, and 3 shall be entitled to run the said market without the involvement of the respondent number 4.
Lordship, there is another direction to the petitioner, Lordship, to take steps on respondent number 4, Lordship.
You have
On the
taken
last order.
I have
Last
filed a affidavit, my lord. The fact is that, my lord, dusty service notice, although he has received the copies, but he has refused to put his signature. And we have taken the speed post also.
This court have also taken note of the affidavit of service, thus the affidavit of service so filed by the petitioner. And it is the opinion of this court that the service is duly complete upon the respondent number 4.
If they like.
I think this matter is disposed of on being abated, Lordship. Your Lordship may kindly come to the order dated 13/8/2025. 13/8/2025, paragraph number 7. Such application be filed on or before so and so. If no such application is substitution is filed on or before is stated.
Application not filed.
Not filed accordingly 24/9/2025 order.
My lord, application has been filed and they have been impleted also.
Well,
On the death of my lord,
এখন IAS নিয়ে গেছে, huh?
yes, perhaps my lord, filed on 29/2025, your lordship. IA number
I'm
62.
seeking substitution of the sole petitioner of the petitioner accompanying with petition
The
taking
ATP
into
order,
account the
24/9/2025.
full details survived by the person who are
I know we have filed amended cost title also.
to substitute the petitioner.
This order is still there, I think, Lord.
By the applicants of the matter. It has been done. Now come to the point.
Right, please, your lordship. Lordship, herein last order, lordship has asked us to file a reply, your lordship. But we could not file because we could only establish contact with the client on last 2 days, your lord, before last 2 days. And yes, your lordship. He wasn't aware of.
You were in contact when you filed this application.
Yes, your lordship.
Then?
But after that, we could not establish any contact with him.
What is
But
the matter about?
Lordship, herein the petitioner's patta land was demolished by the respondent authority, your lordship, without giving notice.
Huh?
Without giving a proper notice, your lordship.
Your property has been?
Demolished, your lordship. Part of my property. They say the demolished property is of.
Okay, final opportunity granted.
Yes, your lordship.
So you have not. So now we are considering as per what it is.
Lordship, if 1
I
week
won't
time will
grant
be
any
given, your lordship.
opportunity.
I'll just place the materials on
What is
record.
the stand of the respondent number 7?
Lordship, they
Yes,
say.
yes. The respondents, what is the stand?
Respondent number 2, Lordship, the affidavit is filed on behalf of respondent number 2.
What does it say?
Lordship, may I, this paragraph number 4. The petitioner has purchased a land measuring 4.5 acres covered by Doug number so and so under PP number so and so, so and so, an entire said land has been sold out to so. Again, he had purchased land measuring 1 katha 10 acres covered by Doug number 1049 under same patta and kisam, and from that land again he had sold 0.5 acres of the land. Hence, as per records of land measuring 1 katha 10 acres are in the name of the petitioner under patta number 53. Further, as per land record, the name of the petitioner also recorded against land measuring 12 acres of land under Doug number 1048 under Lanka. So, total land measuring 2 katha 2 acres are actually recorded in the name of the petitioner number, not 2 katha 7 acres. Accordingly, Lordship, the next paragraph number 7. Reflection. Then 6, Lordship, are not, it may be stated that the petitioner had illegally expanded his original constructed old RCC building, and the rooms constructed by the petitioner expanding the old RCC building falls under Doug number 1038 of Gov. Then paragraph 7, next page. So as a part of the expanded rooms was evicted on 19/2/2017 as per section 18(2) of the Assam Land Revenue Regulation.
19/2/2017.
Yes. And Lordship, in this regard, a general notice has also been issued by the Lanka Municipal Board. That is reflected in it at page, paragraph 8.
Okay. Now. Heard the learned counsel appearing on behalf of the petitioner.
Lordship, if I may,
yes,
take your lordship to Annexure D of the affidavit in opposition filed by them, your lordship. That is page number 14. That is the general notice they have given.
Understood.
Lordship.
You are asking for what?
Lordship, I am asking for a compensation because.
No compensation. Because these are allegations being made against you.
Yes, your
Whatever may be, I've therefore asked you to file an
yes, your lordship,
affidavit.
but lordship,
When your senior appeared on the last occasion, I still remember distinctly. I told him that without that reply to the affidavit, you have no case.
yes, your lordship, but lordship, if you make lordship grant me 3 days time at least, your lordship.
For what?
For filing my reply, I'll be filing it,
Okay, 10,000 cost.
lordship.
10,000 cost because this is the last chance I have given. When I have given a last chance,
Yes, your
how can I do so?
But excluding the cost, your lordship may give me time.
Huh?
Excluding the cost, my lord, lordship may give me time for at least 3-4 days, your lordship. I'll
I'll
file
give
it.
you 3-4 months,
No,
but with
no.
cost of 10,000.
Affidavit, my lords, affidavit filed much earlier. They have not responded.
Ah, that is why in the affidavit was filed in 2017.
Yes.
No, nothing doing.
Then contempt petition also filed, that is also by the. Thereafter, the contempt petition was also filed, that is also closed now.
Heard Mr. So-and-so, the learned counsel appearing on behalf. Mr. H. Sharma appears on behalf of the respondent numbers 2, 3, 2, 4, 2 and 4.
Lordship, 2 and 4.
And Mr. Mr. Chaudhary, you are paying for?
I'm for 3 and my lord, 5.
3 and 5. And who appears for 6 and 7? So-and-so. The present petition has been filed by the petitioner. Seeking compensation from the respondent authorities for assaulting and damaging his life and property. Over the plot of land under DAG number 1049, 1636 of Patna number 53 and 97 within village Lanka town within Lanka revenue circle in the district of Hosai. It is the case of the petitioner herein is that the petitioner is the absolute owner of a plot of land measuring 2 kathas 7 lechas covered by Patta number 57, 97 and DAG number 1049, 1636 under Moza Lanka within Lanka revenue circle in the district of Hosai. In that regard, the petitioner have enclosed the copy of the Jamabandi as annexure 1 to the as annexure 1 and 1A to the writ petition. It is the further case of the petitioner that the petitioner had constructed a 2-story RCC building over the said plot of land. On 19/2/2017 at around 9 a.m., the respondent number 5, 6 and 7 and few other officials under the Deputy Commissioner Hojai, Lanka Municipal Board, Lanka Revenue Circle and Lanka Police Station arrived in front of the building with armed police and demolished a portion of the petitioner's building. Photographs in that regard have been enclosed. Being aggrieved by the action on the part of the respondent authorities, as well as the private respondents who are officials of the the Lanka Municipal Board, Lanka Revenue Circle, as well as the Lanka Police Station The present writ petition has been filed seeking the reliefs as aforementioned. An affidavit in opposition has been filed by the respondent number 2 on 26/7/2017, wherein at paragraph number 4, it was categorically mentioned that the petitioner has incorrectly stated in the writ petition that the petitioner is the owner of 2 kathas 7 lechas of land. It was mentioned with details that the petitioner's ownership was only limited to 2 katha 2 lechas of land, and in that regard have enclosed letters dated 8/5/2017 and 19/6/2017. Further to that, it was also mentioned that the petitioner's building was standing over a government dag being dag number 1038, which is a government reserved land and reserved as Gobat. It is in exercise of the powers under Rule 18(2) of the Assam Land and Revenue Regulation 1886 of the settlement rules framed under the Assam that action was taken upon the petitioner. Further to that, it was also mentioned that the Lanka Municipal Board had also issued a general notice on 13/1/2017. Full stop. The respondent number 7 have also filed an affidavit in opposition on 30/11/2017, wherein he stated that he was present as per the direction of the SP Hojai along with a police team consisting of CRPF, APBN, WP/C and Thana Police, headed by the DYSP (HQ) Hojai, executing the law and order duty at the spot of eviction on 19/2/2017. It was further mentioned that an FIR was filed against the petitioner and 3 others for illegally obstructing the government servant to do their official duty and pelting stones to the persons who were engaged in eviction duty. The said FIR was registered as Lanka PS case number 109/07. It was further mentioned that under no circumstances the respondent number 7 can be personally liable, taking into account that he was present in the eviction on account while discharging his duty to maintain the law and order maintain the law and order as per the requisition of the circle officer. These affidavits were filed in the year 2017 and the petitioner thereupon did not file any reply. When the matter was listed before this court on 24/7/2026, this court granted a final opportunity to the petitioners to file a reply to the affidavit filed by the respondent number 2 and 7. However, in spite of that, no affidavit has been filed. The question arises in the present facts as to whether this court should impose whether the actions on the part of the respondent authorities constitutes a constitutional tort for awarding damages. The materials on record clearly show that though the petitioner claimed that he is the owner of 2/7 lectures of land, but the same said aspect have been denied. And it was categorically mentioned that the petitioner's land only is to the extent of 2/2 lectures. In addition to that, it was also mentioned that the petitioner building was encroaching upon the government dag number 1038, which is reserved as Gauhati. Under such circumstances, if the petitioner's building was standing upon a government land, which is dag number 1038, and the said aspect having not been denied, this court cannot hold that the respondent authorities have taken actions, have violated the petitioner's constitutional rights to be entitled to and thereby to impose compensation against the respondents on the commission of a constitutional tort. Apart from that, the aspect as to whether any damages have been caused to the petitioner and to what extent and how much are questions of facts which cannot be decided in the instant proceedings unless which can only be decided in a competent court of civil jurisdiction. Therefore, it is the opinion of this court that this is not a case which should come within the ambit of a constitutional tort. Apart from that, any other damages, loss or damages caused on account of demolition of the petitioner's building is a question of assessment which can only be done before a court wherein evidence can be led. Accordingly, the instant with petition stands disposed of with the following observations and directions. This court is not inclined, this court, from the materials on record, this court is of the opinion that a case of constitutional tort has not been able to be made, is not made out in the present facts and circumstances of the case. Accordingly, the question of imposition of any damages, any compensation, of imposing any, or the question of directing the respondent authorities to make payment of compensation to the petitioner does not arise. Right. Accordingly, the writ petition stands dismissed. Number 2. The dismissal of the instant writ petition, however, shall not preclude the petitioner to approach the competent court of civil jurisdiction to the loss suffered by the petitioner on account of the demolition of the building beyond the building. And in that, it is however, it is further observed that in the circumstance such suit is filed, the period from 28 to 2017 till date be excluded while computing the period of limitation.
And our specific, Lordship, not necessary. No, our stand was there that no eviction operation was conducted on so and so date on the PP land of the petitioner as claimed by the petitioner.
Huh?
No eviction operation was conducted on 19 to 2027 on the PP land of the petitioner as claimed by the petitioner. So no eviction drive was conducted on the land of the petitioner.
That are line
Much okay.
May it please your lordship.
What is this?
Lordship, this matter relates to a certain impugned order which has been passed by the respondent authorities seeking a compensation for an alleged work that is not being completed. Lordship, however, at the outset, I would like to inform your lordship, this matter was being handled by Mr. R.M. Dekar. However, he could not be here since his house is waterlogged completely and he has not been able to leave. I am there on his behalf, your lordship. The
It's
respondents
okay.
have till date
No,
not
no,
filed
no,
an
wait,
affidavit.
wait. What about the service upon the respondents?
The service is completed. The
You are asking
respondents
the
have-
money from whom?
From me, the petitioner, your lordship.
Huh?
Lordship, what had happened?
You are asking the money from whom?
I am not asking from NPCC, your lordship.
Asking the money.
Lordship, I had participated in a tender process. I had completed 80% of the work. On that, after that,
Who is representing NPCC?
on Mr.
They are not.
Lordship, on last occasion also, they were not here.
Service?
Service is complete, your lordship. They have entered appearance also.
They have?
They have, lordship.
Where is the peer?
Lordship, Mr.
A.
S. Z. Rahman and K. Das.
Huh?
They are not here, your lordship, today.
None appears on behalf of the respondents when the matter is called. For the ends of justice, the matter stands adjourned to be listed again on 14th of September 2026. It is observed that if the respondent is not represented, this court shall proceed with the disposal of the writ petition. Shall proceed with the present proceedings on the next date in the absence.
Lordship, the interim orders may continue, your
The
lordship.
interim order passed earlier shall continue till the disposal of the writ petition.
Much obliged.
What is this?
May I please, Lordship, I am appearing on behalf of D. Ghosh.
What are you asking for?
Lordship, it is a maternal death case. The petitioner wife died in 2016 during her third pregnancy, due to some medical negligence.
I have received some instruction, my lord, file affidavit.
2019 matter after 7 years. Does it show properly?
My lord, in this case, my lord, the petitioner Yes, sir.
Final opportunity is given to the Health and Family Welfare Department. Who is responsible? Final opportunity is granted to the respondents to bring on, to all the respondents, to bring on record their stand, failing which this court shall proceed to dispose of the writ petition on the basis of the materials available on record. This matter again on 28th of September 2026. The affidavits on behalf of the respondents be filed on or before the next day. On or before 25th of September. All of you, it goes to all of you.
May I please, Lordship? Lordship, going through the last order. Lordship, some instruction is required regarding the extension of ownership certificate. Lordship, kindly.
Not possible. Impossible.
Lordship, kindly
What I'm asking is an impossible feat.
Temporarily, they can be taken, but they have to be brought back to Assam.
Forget about that. Nowadays, you cannot do all these things. This has to be done by the HPC.
Yes, sir.
Go to the HPC, not here. Why should we do? Transit permit, you are not issuing it.
No, ma'am. And as per the last order dated 29/9/2023, my lord, we had pointed out that the ownership certificate annexed here had already expired in 2023, ma'am.
Then
Last para, Lordship.
you have been granted leave to apply for renewal, have you?
Lordship, regarding some instruction required, Lordship.
No.
Lack of instruction from the client.
Not be. And nowadays, too, you cannot get it. You cannot transfer. It is a big issue. That day I was taking the matter of Joymala. It was too big. And don't repeat. Now from Joymala, let us not come to Kanchi. It is Kanchi?
Kanchi.
Let's not come to Kanchi. Can't be given like this. Nowadays, too, that day, the Supreme Court had passed the direction as to how captive elephants are to be kept and what are the requirements. This is, I think,
In
19th of August.
case, I think.
19th of August, this order is passed. Why do you want it? The learned counsel appearing on behalf of the petitioner. When the instant writ petition was listed on 29/9/2023, it was brought to the notice of this court that the ownership certificate of the petitioner had expired. And this court granted the petitioner leave to apply for renewal / extension of the ownership certificate. Almost 3 years have passed by, but the petitioner, counsel for the petitioner has no instructions in that regard. This matter again on 28th of August 2026. In the meantime, the counsel for the petitioner shall obtain instruction as to whether there has been any renewal granted of the ownership of the petitioner. Yes.
Your lordship directed, my lord, on 4th September, my lord, to seek instruction, my lord, how the cell deeds will not be given to us, which were registered already.
Yes, what is your instruction?
some instruction is there, madam. Is it a it has been annexed with the my affidavit also, madam.
What?
Is
Is
it-
this the reason?
No, no, not my lord.
Because it is
I was a
pending
bit
before the
confused.
civil
No, no,
court.
no, 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 my lord. I was a bit confused, my lord. These are part of the record, my lord.
Understood. This is the reason senior sub-registrar saying that
Uh,
since the matter is sub judice in the court of the Honorable Civil Judge so-and-so, as miscase number so-and-so and so-and-so, therefore question of returning the original seller depends upon the decision. What? Is there an injunction against you?
there is
injunction.
What is the injunction?
My lord, initially injunction was granted, interim injunction that no sale deed will be executed. Later on, my lord, it was directed to maintain the status quo. My lord.
So, how does it have, no sale deed has to be executed? Is it mentioned no sale deed to be registered? Where is the injunction? Show us.
The injunction I have not filed, my lord.
Huh?
Injunction order I have not filed. My lord. These are the
Then we ask them to give it to them within 7 days. You can't keep it like this. My goodness.
But in fact, the sale deed was not registered, my lord.
registered.
And when was the sale deed executed?
My lord, it was executed, my lord, on 25/1/22. On
25?
25/1/22.
Then
My lord, already, my lord, what happened, my lord? They prayed for execution of the sale deed on commission, my lord. They prayed on 21/1/22. Then, my lord, on 24/1/2022, one order was passed at, that is at page 44, my lord. So kept in abeyance the sale permission, my lord, in view of the occasion, page 44 of the repetition, my lord.
Is
Really?
44.
3 sale deeds and 1 family settlement deed was given. The rest 7 sale deeds were kept.
Then
Then, my lord, on 25/1 only the signs were taken on the sale deeds, but it was not registered, my lord.
what is that?
But registered, my lord, on commission because 7 sale deeds, 3 sale deeds has been given to us.
Huh?
Out of 10, 3 sale deeds has been given to us.
Then
7 has not been given, my lord.
then
It was executed on commission, my lord. How we, my land friends say,
My lord, may kindly see the affidavit filed by respondent number 2, my lord.
who is respondent number 2?
Respondent number 2 is, my lord, Deputy Commissioner, my lord.
What does he say?
My lord, paragraph 3, my lord.
Okay, produce that. You do one thing. Next week, produce the unregistered or what are the document before this court. Matter
Paragraph
over.
3.
No. This type of injunction cannot be the basis. First of all, the injunction will only operate inter partes. Register, sub-register has no business out there unless you are in hand in glove with Mr. Gupta. Are you? Then, matter.
I'll produce it. Because if it says, my lord, my affidavit says, my lord, had not been registered. If had not been registered, as per the submission made by my senior friend, I'll produce the unregistered if it is.
Whatever may be, produce that document. Which one? What is the number, the sale deed number? You got a number?
My lord,
Sale deed has not been, my lord, it says that.
Registered, so there is.
three sale deeds has been given to us.
Directing restaurant to immediately complete the process of registration. You also say that it has not been registered. See your prayer.
My lord, that was executed, my lord, in commission, my lord. Thereafter, what they have done, my lord, because 3 salaries has been given to us out of 10 and 1 family settlement. 4 has been given to us. And rest, what they have to do, my lord, I don't know, my lord. How they will
The
do
state
it?
commission was allowed on 25/1/2022. And the petitioner and landlords entered into 10 agreements. It's their pleadings.
10
And 1 deed of family settlement and commission. However, only 3 agreements and
3
1
salary
deed of
certificates.
family settlement were given to the parties concerned. Rest 7 are not given. So my prayer, my submission would be, my lord, that it has not been executed, my
Executed on commission.
Executed but not registered.
not registered.
Because commissioner will take the salary, my lord, and they will do it what?
Has the circle officer submitted the report?
What is there in the one report is there, madam.
No, no, in
Seven-
pursuant
75.
to the order of 24/1/2022, the circle officer was supposed to submit a report. Has he
Annexure B,
submitted?
my lord, 75, page 75.
But whatever may be, page 77 cannot be the reason. We have no business out there. You have no business to do this.
My lord, this also it finds little bit of context. It says, my lord, returning of the original said is depend upon the decisions.
No, no, kindly see, since the matter is sub judice in the
Sir,
court of so and so,
I have gone through.
therefore question of returning does not, of the original sale deeds depends upon the decision of the court. Then,
Other end.
so therefore, when I saw this, my question is produce the sale deeds.
Yes, yes. Yes, yes, I got it. Because it's clearly stating the original sale deeds.
Yes, it says. Then the question will arise as to whether this should have been registered or not. That is another aspect of the matter which Mr. Sahiwala knows how to tackle it. There is one judgment of the 3 judges bench of the Supreme Court. Take it up on that. But this is you cannot. The petitioner herein is aggrieved. Petitioner or petitioners herein are aggrieved by the actions on the part of the respondent authorities in not completing the process of registration of the sale deeds which were executed by the landowners on commission and delivered the respective sale deeds to the petitioners. This court duly takes note of a communication issued by the senior sub-register Tinsukia wherein it is mentioned that on account of the matter being sub judice in the Court of the Learned Civil Judge Tinsukia as per Miss Case number 47/2022 arising out of title suit number 026/2022. The question of returning the original sale deed depends upon the decision and order of the Learned Court of the Civil Judge Tinsukia. This court have duly perused the orders passed in Miss Case J case number 47/2022, wherein the injunction which have been passed is only against the petitioners. Injunction is against you, against the landowners, not to execute the deed of sale. However, the deeds of sale were executed prior to the injunction order which was passed. Not to, yeah, good sir. The injunction order was passed on 4/4/2022, whereas the execution of the sale deeds were done on 25/1/2022. There is no embargo as per the orders passed in Ms. J case number 47/2022 arising out of title suit number 226/2022 for the senior sub-registrar Tinsukia to hand over the sale deeds to the petitioners. Accordingly, it has been submitted by Mr. Endas that the said sale deeds have not been registered. So, considering the above, this court directs the senior sub-registrar Tinsukia to produce the sale deeds on the next date before this court. This is the matter on 11th of September 2026. Yes, Mr. Mukherjee.
The previous occasion, both the parties were directed to produce certain documents, Your Lordship. The sale deed was not legible, which was annexed with the petition.
Ah, yes,
So,
yes,
respectively,
I remember. Get a copy of the original sale deed and further as to whether any permission was taken prior to the execution of the deed of sale.
Lordship, we have received instruction regarding both the queries, Lordship.
Anyways, this matter can't happen. Any interim orders to be extended? Because I have to rise at 3:15. Whatever it may be, we'll take a convenient date.
Yes.
Hey, I'm a mantu reference no?
Lordship, item number 49, Lordship, intake order.
Tell them they will increase. পাহৰি গৈছে নেকি? Huh?
Lordship, one more.
36 minutes.
Lordship, we have to file our affidavit in reply, Lordship. 2 weeks time may be granted, Lordship. Yesterday we have received instruction.
Which item?
49, Lordship.
Already we have deposited the amount which is the assessed Tala. Is it due to dispute by apportionment in its before that now?
Okay, we'll take
Now, due to this, they are not giving possession, we are unable to take possession of this.
we take it up on 26th.
Right.
26th at 2 p.m.
Lordship, affidavit is to be filed in this case.
What?
In item number, this one, in item number 49. Only yesterday the affidavit has been filed. Now they are showing the urgency, but they filed the affidavit only yesterday, Lordship. At least 1 week time may be given, Lordship. We have to get the necessary instruction from the petitioner also, Lordship. Can it be fixed on Friday, Lordship?
Yeah. We'll have it on 28th.
28th, Lordship. Yes, Lordship. Alright. Interim order may be continued, Lordship.
Interim order to-
Item number
at
36.
2 p.m. The final disposal.
Alright.
If you
Item
want to
number
file your reply, file your reply.
Lordship, regarding the item number 24, Lordship, your Lordship directed to place the matter before the mediator.
But only one sitting was held, thereafter could not held because the petitioners could not present due to flood, due to flood. Lordship, one sitting is required, so kindly producer order dated 18/8, the mediator has sought time for another sitting, so kindly allows.
We'll see when it will give a date, short date.
Item number 36 interim may be continued. 36.
They will in,